New case? New case? Yes. Urban land civil.
No, it's the plots greenfield. I map also.
Non-implementation of this 4 to 16 method as well as implementation. This amount of direction that I call implementation. I request for tomorrow allow my implementation for this.
For complete petition, you want it to be taken up tomorrow. Friday.
Cooperative societies. In this case,
Am I having cooperative societies? Kindly check.
Okay, not put up case in there. So many times it is coming from that. Kindly put it tomorrow.
Tomorrow, Thursday and Friday. Any of the days will come up.
Petitions of 2023 petitioners are aging about 85 and 86.
What is the relief?
The land has been acquired by us when the district collector asked an order in this matter. The reversal order has
By acquisition matter has gone before district collector. Why the dispute has gone before district collector, madam, in acquisition? Friday.
parents of living land by land official respondent.
All others kindly give slips. For posting, don't mention. Please give this. New matter, madam. New matter, please give. Old matter, don't mention. Please give. All new matters will come today. All lunch motions, general. Next week.
Petitioner by suppressing the real facts brought an entry model basing on the said item, but they approached the common civil court and trying to dispose me
Tomorrow. Yes. Matters in list. Call PH by side.
Page wise mention. Page number 1.
You want, I will get it as lunch motion. You want tomorrow? Tomorrow.
Page number 1, item 1 to 19. Page number 2, 3 to 38. Page number 3, item 39 to 54.
Your Lordship, item 113, Your Lordship. Item 113, Your Lordship. Item 113, Your Lordship. May be taken up at 2:30, Your Lordship. You know, most urgency, Your Lordship. All of a sudden, Raith Bandh amount stopped.
Wait. Why are you jumping to 113?
Because it may not be reached since 10 last 5-6 months it is coming, but it is not reaching, Your Lordship.
66.
Page number 4, item 55 to 17.
266, why 230? What urgency? I think it will reach, yes, 230. 70. Petrol bunk matter, yes, 230.
Page number 5, item
Inform
71.
GP home.
86, 87, 88, deviation of the canal, 230.
Lordships,
87, 88.
82.
Lordships, Act number 82. Lordships, so please just permitted make a mention, Lordships. Act number 82, yesterday's matter, Lordships.
Yes.
Lordships directed to be listed today in the Lordships 215 caption, 230 caption. It's not listed. Matter pertains to Lordships Urban Land Ceiling Act.
Yes, I'll take up. Don't worry. 230, I'll take.
Page number
86, 87, 88. Deviation of the canal, 30.
84, you're right.
Item 85.
Yes.
84.
84.
Item 85. 30 minutes.
I am completing all matters. I think I should complete it. 80?
85 minutes.
Yes.
Page number 6, item 83 to
96 already, it is at 230.
Next, 105.
Page number 7, item 96 to
105.
105.
Only the under the entire part of the responsibility.
If all of you do not mention, I will complete the entire list.
Item 1.
Yesterday, because Mr. Prakash Tuji and Mr. Ratan Singh, senior counsel, I was not able to complete. Today I complete, I don't have finding next. Yes. Inform the other side. I'm not yet.
Page number 8, 111 to 190.
1-1. So, madam, when the matter reaches you, inform. How should I take out file like this? Yes. Why was it adjourned?
Meeting of instructions, your lordship, that people, the respondents are saying.
Deepens, GPA,
People are not available, they are saying that we are.
230.
Like.
230, next.
Page number 9, item 120 to 129.
Item 123. I think 230 of 120 is because of status quo, the observance confidence.
123.
The wicket petition.
Who is for the petitioner? You informed him?
Yes.
Inform? Please inform. When the councils are coming,
Implementation of the court previous.
121. It is almost 50% of the matters I have noted now. What is the use of mentioning? Lawyers also should use discretion. You may be having 10 matters which are urgent in your office. You should mention one by one, which is to be given priority. You should decide. You cannot give all the numbers. Otherwise, you do one thing. I will take up one lawyer's case one day. I'll post all his matters. I'll complete. For next 1 year, don't come to my court. That is better, I think. How many mentions? He said, I'll complete it.
Item 129, implementation, allocation and request petition. Right.
ULC matter, let it reach. Let it. Especially this ULC matter, hotly contested. Let it reach. If the councils are here, I'll pass orders now.
I informed all of you.
Absence of lawyers.
26 minutes, what are the last order?
Which order?
Some ballot flats are allotted ballot, government flats, and the.
Area, which area?
This one, you will also pass order on the same order, same flat.
Give the copy. 230. 230.
Item 20, my lord.
Madam. Which matter?
Item 120, the matter is pertaining to the SC candidates, my lord, who have dig the land which was in a hilitarian stage, my lord. Now they are not being given even the water, my lord. The other side is encrypting them and they are restricting the water. They have stored the seeds, but they are not able to get the water from the other sources, and the field is affected, my lord. You let me have it at 2:30 today. All their exercise will be futile, my lord, if they don't be permitted to have water in their field.
Yes, 230.
24 minutes. Petitions on the 10 land to the petitioner.
that we made a representation of tomorrow, Tahsildar, to take action, not the person who are not third party to interest in this position, take it to the land in the other side, to go that side. So I made a representation to Tahsildar, not keep to take action, to.
You are mentioning or you are arguing your case? Better argue and pass orders. Art of mentioning. You should know how to mention. 230. That side has to come. Yes, unless the other side comes. Next.
Item number 1, Mr. Dr. Venkateshwarlu. For 5 minutes, sir.
Senior counsel.
Who?
Senior counsel, my right.
For being mentioned, why Mayur Reddy is coming? Let me see.
Yes, requested.
This one matter.
Item 2, Mr. Damodar Reddy.
Yesterday's matter.
Yes.
See,
Case number 26 for a moment.
see what has happened after 2020 Act came into force. How your appeal will be numbered under 500.
Court has referred only 1971 Act. That's why we are paying number 26.
First court has referred, go and request the first court to clarify the order. When there is no appeal provision, how can I pass interim order? Take clarification, this.
That's why we are paying number.
Mr. Damodar Reddy,
We are paying number 26.
I'll ask, you argued, sir.
Under general clause.
You have argued several matters today. Today there is 5-way regularization. Suppose you are not challenged. Let us assume it is passed about 10 years back. You are not challenged. What is the remedy? Writ petition. Why have you not taken permission from court number 1 when the matter reached, and why did you say that you will file 5-5 appeal? 5-5 under which act? Which act? Repealed Act. You will file appeal under Repealed Act.
Under general clause, we
Don't say first court has passed. You argued that point. So the court permitted you to withdraw the writ appeal. Why did you argue that point when you know that act is repealed? 5-5 provision is not there in the statute book.
that was argued under general.
Just take clarification, instead of doing that, file writ petition challenging 5-way regularization.
Page number 26, paragraph 3, I said in the appeal, that it is further submitted that though ROR Act 1971 was repealed by ROR Act 2020, as the impugned order passed by the first respondent is only under the provisions of ROR Act 1971, and therefore even after repeal Act ROR Act 1971, the present appeal under Section 55 Act is maintainable as there is no provision under the new ROR Act 2020 to file any appeal. And even as per Section 5 of General Clause Act 1970.
Mr. Damodar Reddy, you yourself argued so many matters, and you are.
That is there, under General Clause Act, only the RDO, titles are passed to the
I
RDO.
want to take risk. It is up to you. You are saying under General Clause Act, Tahsildar. That is pending case. If you want, let the notices go to the respondent.
It is observed not in the during report of the RDO.
Why have you not invited an order on General Clauses Act? You should have asked done a division bench to make an observation that under Section 6 of General Clause Act,
Yes.
General Clause, you are saved and orders which were passed. You should have asked for that. I'll do one thing. I will not pass any interim order. I'll issue notice. Notice to respondent. Let him take clarification.
Item three, the circular.
Elections made will be every last, given the report, page number. Register has been 4 acres 22 guntas. And as per surveying data, only 3 acres 5 guntas.
There is a court case pending, so merely because your neighbor objects, this man will stop, huh? You should tell him what is, which court case is pending. If we shall get instruction. Put in your motion.
Item four, Mrs. Jagdishwar Reddy.
His my father's two order. Initially, order coming in my building. The next order no idea is method application. Complete developed and construction. But without notice, mirror second order is found. But first of all, mirror, kernel has no power of review, mirror. But they reviews the order mirror without there being any notice to mirror.
Order was passed in pill,
But bill orders were in respect of.
giving general directions to entertain, whether you call review or reopen or recall, it is the same. There was general direction because the special tribunal constituted under section 16 was passing orders without giving opportunity. So general directions were passed.
It is not in the general case, it is the recent case, last my TSHIGHCOURT also, the order is
Where,
21.
where is the first order?
First order is a page 2.
First order, second order,
Second order is page 18. Tribunal appeals to Miller to the fact that there is Miller unoption response case start,
second order is page 18.
page 18.
Attention of the appellate petition to respond the children of so and so.
First page of intact, first page of the order is intact. After that, they changes the order. And the
Yes, that pill order is applicable only to orders which were passed prior to that. How did he entertain? Where is the review power? Where is the second order?
page 21.
Where did he say that it is, no, second order I said,
Second order is
page 18.
first order is at page 20. This order, first order is in my favor, second order is in favor of the unoption. Order is the same, operative portion changes.
How did you get it?
RTI got it. But even that should not get it. It is a duty of the tribunal to pass the order whichever is in the file.
If the order is not pronounced and it is there in the
Two authorities are there.
computer system,
Two authorities are there. Even if whatever I take your assessment to the extent of order,
There is no date also.
but if authority came to the conclusion that they were beyond the back of the petitioner, order is passed. But it was reflected in the two orders. Thereafter, first order states that it is bad. Second order it is correct.
you are filed a suit for cancellation of duty.
Page 18, my lord.
Yes.
Kindly see in the first paragraph, second paragraph, accordingly notices were issued.
And
to the
the
five
late
and suit was called on 27/8, 15/9 and 15/10. Upon transfer of deciding officer, the case reopened, heard on 29/4 and finally restored to office. But in page 21, it states that my lord, accordingly notices were issued to the concerned, the case was called on 27/8 and 25/9 and finally on 15/10. Thereafter, it was reopened because due to transfers of this. Was clearly mentioned, my lord, the case is reopened, heard on 29/4/23 and finally reserve for auction. This was the final.
Which para?
Put on page 18, second paragraph. Last but third line.
Did you receive it?
So
Did you officially receive the order?
I am on the ground that Milord.
Unless order is dispatched, it cannot be.
One officer of the tribunal is there. One of the officer is there, same officer, both the orders signed it, Milord.
So what?
One of the presiding officer is enough, Milord, to communicate the order.
Yesterday I have passed one order of today. What happened in Mr. Damodar in this matter? Item number 2. I passed order yesterday. I did not sign. I have recalled the order.
Your officer not signed. The presiding is the officer of 2, Milord. One of the officer is signed it. Now we look into this signature for page 23.
Someone
Page 23.
gave information to you saying that the collector then before transfer passed this order.
No.
You conveniently filed RTO application. Then you got certified copy of that order. Now you are saying when this order, suppose this order was in your favor, would you have disclosed the earlier order? Suppose if second order was in your favor, would you have disclosed the earlier order? No, you should, because second order is against you. Now you are saying there is a first order.
Order is also my favor. Not to take you to the order which was passed by both the authorities.
Yeah, unfortunately, the staff are so mischievous. They are giving secret information.
No,
to the litigant. How did you know? How did you know that order was passed?
I obtained this.
On that day, hearing was there. Was the lawyer present in the collectorate?
Any notice will letter for the.
Without notice, how did you know collector passed order?
I was communicated under RTA when I obtained the card.
Why did you apply under RTA Act? How did you know about the order?
I need entire papers, how they reviewed the order, I want to know it. I take your lordship to the part of the order which they passed.
When order was not passed, how did you know it was passed? Every order has to be pronounced in open court. There was no date of hearing. There was no dispatch. Now, the problem we are facing is with this software system.
The ground which I
Preliminary, he has prepared it. What I assume is, he wanted to pronounce, but he was transferred. He did not sign it.
Yes, my lord, and it is on the record. But when the authorities, my lord, second authority wants to review it, my lord, he has to issue notice to the basic, but notice has to issue to me. But that was not issued. Even then, I take your lordship to the part of state.
Notice to respond number 5.
The order part, my lord. Order says that, my lord, authority, my lord, lower authority has, my lord, not followed any principles of natural justice. That was the order confirmed by both the authorities.
You answer only one point. No further arguments. Only one point you clarify. How did your client know? Let me complete my question. You know what is my question. Why are you answering before hearing?
Your lordship says, my lord,
How did your client know that order was passed on so and so date? Why did he file RTA application? First answer that point.
I need the record, my lord, how he has, my lord, passed the order. I need a verification from the authorities. Not I left it, my lord.
Mr. Jagdish Reddy, I am telling you, yes, yesterday I passed one order. Suppose you are the lawyer yesterday,
But there,
you know, right? Today there is live streaming. Everyone knows. Be complete, don't assume. I am telling you, suppose you have argued one matter yesterday. I passed one order. If this open live streaming and recording is not there, you could have said, no, this court passed some other order, not this order. You may file for being mentioned petition so on. Now with live streaming it is different because you can find out what really happened and transferred in the court. Forget. In the collectorate office, when a matter was argued, your client does not know. On that day, suppose 30th September matter was to be decided, orders 11, it 2811 it will come up.
Page 18, well, sorry, well, I'm not present. What are findings of the authority they are looking to for a moment, well,
I will not go into the merits now.
for a moment, well,
You, who filed suit for cancellation of gift deed?
but
Your client filed,
but clients are fine, well,
let it come.
it was, it's a suit for cancellation, sorry, well, unofficial respondent file, well, against the cancellation of the well, if did, unofficial respondent file suit. Well, for a moment, I am not pressing, well, for a moment, well, that is judgment, well, order itself, I want to read, well, 4 lines of it. I'm nothing.
You argued one point.
And I only said, well, this is irregularity committed by the authorities, well.
What is the
I want to brought to the notice of this court, well.
Yes, you argued.
Yes, page 19, well. I will permit it from the order portion itself, you know. And there is the material presented and the records to be located. I said that I also issued persistent order, data issued, pre-sent to the related, in the respect of man. Along with other certain members, which are the petition of the with individuals here. The names of the respondent to Omar Asif is also included in the case of the, that is an option restitute of the joint property. However, as per the latest record, only the name of Omar Asif is reflected in the original second. It is evident that there is a gift settlement due to for an extent of date of 33 in 7 number 225 is cleared. MR other and results to them, but as per the income certificate, they mean the same is found cancelled or cancelled.
Who is Omar Arif?
That is unofficial.
Omar Arif.
Unofficial. That is one corresponding of 5. This authority is inclined to pursue that MD Omar Asif has fraudulently got his name incorporated in the revenue record, suppressing the cancel date, and the Tehsildar Shamipet has incorporated the change in the revenue record, including the use position. But that's up to it is my favor. Thereafter, however, it has come to notice that respondent has filed and OS number 20. So against the cancellation of the said gift deed, and the same is pending for adjudication. On the file of additional signature immediate VHF transaction. In view of the above circumstances, the customer does not intended to interfere with the matter. This position only legal. Well, authority himself came to a conclusion that order which was they obtained, the name which was.
How can gift deed be unilaterally cancelled?
If that has to be gone into ballot, if that has to be gone into ballot, one of the.
So if a special tribunal gives a finding that is in your favor, first part. Second part is against you. What you said is correct. I am asking you, I should ignore law, legal position.
Legal position.
How unilateral gift deed is valid? Cancellation of gift deed.
Lawsuit comes to the ballot, I take your lawsuit to the ballot, the mutation proceedings will be issued. But mutation proceedings will.
Unfortunately, favorable observation is a wrong observation.
Lawsuit that was the same thing what is the earlier order. That is the same thing which was extracted when this order was that order they want to change the operative portion.
Contrary to rule 26K registration rules. Yes. Alienation, Justice L. Narasimha Reddy's judgment, alienation includes Justice Narasimha Reddy has covered both. One is agreement of sale cum GP and also gift deed.
For a moment, mutation proceedings in between the brothers, it was taken place between all the persons. I take your lawsuit to the mutation proceedings. That is the page 39. The instance of this unofficial respondent. Page 39. Along with this property, entire properties were divided between the brothers. But he gives consent before the authority, he files a suit. But that there is nothing, no orders are there.
Father is petitioner. Father died.
In between the brothers, it was. But even.
Where is the cancellation deed? And show me the suit pleading. Why was it cancelled?
Immediately on the next day it was cancelled. My only request was let them not to eliminate this. The lawsuits was not convenient. In case we are discontinued. Direct time was initially not to pay any start party.
When he filed a suit for cancellation of that cancellation document, why you want that order?
Last week, look into the suit, which are suit of HIGHCOURT.
The order will be passed, you have made out a case, but unfortunately,
When I'm
parents have cancelled this document.
he by paying fraud on the parents, thereof it was cancelled. Immediately on the next day it was cancelled.
I will set aside, first order according to me is not a valid order. Let the respondents come. Has problem about title.
Last week, same status quo, so that I mean.
2 weeks, 21, 11.
Once I made out a case.
This is going to take out person.
Order cannot be survived. They suspended both orders to suspend.
From now onwards, I will not explain anything. I will only keep on passing orders. Now I have the habit of explaining. I'll stop that so that I can dispose of 2 times what I used to do now.
It's a problem.
You said first 2 orders passed. I asked you how did you get RTA information? Then you have given up that argument. Then you said unilateral cancellation. 3rd paragraph was in your favor. 4th paragraph he has changed his mind because civil suit is pending. I said it is contrary to section rule 26K. Then you are now saying.
Last week call for the record ballot. Last week close call for the record ballot. And who played the fraud last week closing? Last week call for the record ballot. I am having entire record ballot which I obtained under RTA.
When the respondents clear, I will pass orders on merits. I may set aside that order. Another ground. I may, because there are 2 contradictions.
Last week may set aside it,
So
order cannot be survived. My only request, order cannot be survived. Last week same as status quo. Last week same status quo, so that you can't entitle for any question.
for your satisfaction, I cannot pass status quo. If you are satisfied with status quo, I am not satisfied with status quo.
I am not going to do anything as now.
But for sake of your moral satisfaction, I cannot subdue my morals.
This may not.
Mr. Jagdish Reddy, you cannot waste my time.
I am not wasting my time. I have to murder. You would like to jawab that.
That is what I am saying. For your moral satisfaction, you want me to
Let them not to say or not to elect. I show that I argue the case before the court.
I said I may allow the writ petition after the respondents
This is
appear.
not list of instruments, that is problem which you are facing.
Yes, anymore. So
Sorry, Milord.
anyhow, don't worry. Don't be sorry.
I am getting it.
Mr. Jagdish Reddy, you don't have to be sorry in my court.
These are we are facing
For how many years you practiced?
for the last 22 years.
22 years. For how many years I practiced?
I know for about 35 years.
I don't know as much you had.
Item 5, Mr. Venkatraju.
Deviance is changes in the revenue reimbursement.
No private interest.
Having standing crop.
No private parties. Why are you saying in the name of third parties and without third parties, why did you file writ petition? I am asking out of two cases, every two cases of this nature, one case you do not make respond, third party against whom allegations made as respond. You want me to pass orders against unknown persons?
No, here, by taking the advantage of the area, even absence of.
Making changes and transferring lands in the name of third parties in survey number so on.
Right, 120 business, and for the standing crop is.
I'll grant entry order if you had made third parties respondent.
Standing crop is there. Standing is there.
See, the purpose is to see third parties have opportunity to oppose the case. Now I pass order.
What happening there? Taking the petri, they're taking advantage of MR point, there is a chance for, and they are making us, especially.
Against whom I should pass order now?
My prayer is not to, by the MR, the direction to the MR. As he is the restoring authority. Cultural land.
GP, today if he opens website to know information about the survey number, will he know whose name is recorded?
He himself filed journal record page 20.
That is true. That is online.
Others may.
Currently, Millard was happening. By taking the, in the absence of passports also, they are transferring the.
Who is
land.
this third party? Kumar Chandrakala.
Mother of the.
Mark, petitioner is
Yadaya. Yes, Yadaya, son of Yadaya. Whose name is recorded?
mother's name.
That's
Mother's name is mother's name.
Millard, one subject. Millard petitioner, there is petty that and she. She is not in a position. They are taken away the mother, his mother, and trying to change. That is different as.
Who has taken mother to sub-registrar's office?
Yes. Relatives.
Relatives. Why are you not making relatives?
Section 5A, section.
Why are you not making relatives party? Your brother or sister, whoever it is.
Specific allegation, the specific. Standing crop is there, and you go through the page 19, you see. Standing crops is there. That is the reason I approached this farm. Except for 1 week and grant the status for agriculture. Because only for limited. There are standing crop is got.
Third parties are trying to make illegal efforts to
There are
make changes.
practical.
GP to get instructions, 1411 motion list.
Standing crop is there.
No, I cannot grant interim order. Your family members, brother or sister should be made respondent.
And one thing, one subject. In the we are facing several problems in the section 5A advantage. Without passbooks, they are transferring the lands by taking the section 5 of Panwar Act. In the absence of passbooks.
The relief you are asking is like an anticipatory bail in writ petition. So for all your future problems, I should pass one order saying that no one should be entertained by the sub-registrar come Tehsildar, and information should be given to you so that you will file objection. So I should say not to entertain any transaction. If your mother is sick, your mother wants to go and execute gift deed, how can I stop her? Can I stop her?
We should have stopped that.
Who? File a civil suit.
And if you find
Take care of your mother, she will execute gift deed in your favor. Otherwise, your brother, sister will come and take her. Whoever it is, then who is the person you are doubting? Motion list.
Item 6, Mr.
It is not maintainable, Venkatraju. But I don't think it's necessary to entertain this writ.
one line of section 5
I only want GP to find out whose names are entered.
Chandrakala mother's name is there.
You names.
New names not entered.
Then how it is maintainable?
That is the reason I am insisting. Can you go to the section 5 of class 4 below?
That is witch hunting, ant spade repel.
They were transferred.
So, this is like ant spade repel in that petitions. I cannot, not maintainable.
Multiple, we take 1 minute. If
I'll pass orders in that case, not maintainable. Better withdraw and come up. Let the cause of action arise.
I will come in. Because section.
For what? I thought if someone has applied for mutation, if you yourself are saying no one has applied for mutation, no cause of action. Without cause of action on mere apprehension that some of your family members may influence your mother because she is sick and take her to sub-registrar's office and create one transfer document.
I will make a part of reading the section. I will text you.
Can you go to a civil court saying that restrain my father or mother from going to sub-registrar office and executing document? Can there be such order?
That is the reason section 5 family class only 5 4 class section 5 and
I am asking you simple question. Today your mother is Patedar, recorded as Patedar. You do not know who is that family member who is playing mischief. According to you, taking advantage of your mother's health condition, some family member may, whoever, in whose, who can he be? Who can be other family member? Who can be other than family member?
Is the problem. And MRO in revenue, especially in the Tamil district, all the models are happening there without title deeds, section 5, section 5 of ROR, they are transferring. This is the 4th case I am facing now. That is the reason I have directly, they are making.
See, in the old age, if these people are not able to take care of mother, you can understand. They are only interested in property, not their mother's health condition. You are worried about your property, not about your mother.
She is in my custody, business custody.
Sunil Kaur.
Yes. Family application is filed.
Page 58.
The application is late.
Application number is there.
57 is application.
Is not
Same number is there?
Yes.
Yes, same. H.
Page 55.
Concern Mr. T.Y. and Charlie.
Find your question and the respondent in considering the petition representation. To show the best application. Not petitioner tried for online application, not, but it is not accepting.
Show me the rejection proof. Petitioner is there.
Item 8, Mr. Rajeshwar Rao.
The demand. 7-9.
7-9. Why can't you wait for some more time? Want me to dispose of? Petition is filed.
Item 9, Mr. Koteshwar Prasad.
Career, that's the granted outside Pata. Is level meter is Pata.
Yes.
Six career standard.
He has a patta.
Is level and 23%.
All your clients are from Boduppal.
60 career, there is lump vendor.
No, I am asking you till now, how many writs you have filed in? He might have become very famous in Boduppal now.
But 60 career, it's a big slum village consisting of 400 acres.
Hope you will not say you have visited this plot also. In several cases, you said you personally went there and asked that. Petitioner is.
The permission, but it is an instant permission. It's a certain measure, have the permission of what?
I'll only say not to interfere without. Are you making instructions?
No, admittedly, lordship may face 23.
I have asked you questions. In many of your cases, I am asking you another question. Same. If you were given outside patta, why did you keep it vacant?
Oh, my lord, I am not kept vacant, my lord, it is outside 23 lots, page 23, not kindly 15, page 15.
Page
15. Is applied for submission. Page 23, my lord, work should be commenced from 6/3/24, construction to complete on 6/9/24.
No. What is your point?
We say that, my lord, whether such a loss, my lord, is.
Find out, I'll say petitioner. Now government wants to utilize it for 2 BHK. They are forcing them to give possession. So what I suggested is, if you post all these matters, I will give them 1 year time. Either construct or surrender. After surrender, government will give them back 2 BHK free of cost. That is better. Yes, in Gadwal matters. So, not your case, other cases. 1981 order, 1991 order, 2001 order, how many orders? And these persons are not constructing houses. It is only for house. Today, if you are not constructing house, his grandfather was allotted house in house site in 1970-80. Now, second generation they have not constructed. Third generation grandson. 30-40 years if you are not constructing, give back the land.
Recall that in those matters also, now inquiry is concluded, but the file itself is not there. So you will return.
Whatever it is, what see, one is whether file is genuine or not. Second, this litigation should not continue for 60 square years, 100 square years. Because 2 reasons. One is 2 BHK, another is 58, 59 GO is there. You construct within 1 year or give back the land to government. Government will construct and give it. They can pool the land, give it to the poor people. 2811.
At the time, the next surrender.
Estate. This suspension as prayed for. 2012. For which case you are waiting, Mr.
Or being mentioned.
Item number one.
Number one.
78 to 93, Lordships have passed a detailed common order for all the survey numbers with regard to the.
This matter is different, that's why I needed clarifications. What has happened? Order copy. Sir Mayur, you gave me this order copy.
Yes.
Here,
In fact, that day, this very same petitioner has gotten on from your lordship.
this is actually same area. Interim order was passed by me, but under stamps and registration. The difference between that case and this case is, here the relief asked is
No, not to insist on
NOC.
No, I am clarifying.
This order, you can,
This order.
same order can be passed on.
Not to insist on UMC was being passed by this honorable court, keeping in view the 22A virus being pending.
So similar order can be.
That has been answered by the division bench not upholding the virus 22A provision. Now, what I am saying is, unless the 22A to B, the lands fall under surplus lands, being surplus lands, the authority has a right to say the principle of prohibitories. Therefore, the petitioner now cannot contain before my lord saying that, ask them to register and release the property. All these properties are under 22A.
What about the Supreme Court order? This one, 1 minute.
According to me, that is the
One. Sir Mayur, wait. What is the intention? Intention of learned counsel is, there is a provisional
Yes, sir.
registration,
Yes.
relief granted by Supreme Court, so
All that was pending 22A only. All that.
pending 22A.
Now it is answered by division bench upholding the provisions.
The interim order, the order which has been given by the Honorable Supreme Court, I have 7 your lordship has seen. The same person, Chintala Kumar Yadav.
Recently, the division bench has disposed of.
Yes, sir. I highly see the written order which I read upon from my lord also. I requested the lead petition to be listed to be argued. His lordship said 19th of October, it's not listed. The lordship will grant at 10 days time.
1 minute.
And all these matters can be argued not because the state has got lot of interest. Having taken the amount under 747, well, the state has to realize. With about 39, 49 applications the apprentice, the virtual state has to. By this honorable
Mr.
court.
Mayur, the learned division bench has upheld this virus of
I just pass on the order.
So I'll pass orders on merits, whether it is covered by ULC or not, I'll pass orders. In other matters, I have passed interim orders, let me dis.
The same one, see that person, Chintala Kumar Yadav, one sponsor. The order which I passed on to your lordship, he got the same order on that. very
Correct,
day.
but last week honorable division bench has
Yes, I've asked it on behalf of the work for the validity of 22 but lordship, please notice.
This is different.
Supreme Court has said it. Supreme Court has said it. Do provisional registration. It has not said that like this, that what they are arguing. Supreme Court order, if your lordship were to see at para 7 for a moment, I just submit that order to your lordship, which is the basis of this order. In fact, Mr. Vedla Venkatramana and myself are appearing in item 44 also for the same survey number, 78 to 93 months. In that, this Supreme Court judgment is the basis of nearly 50 to 60 judgments of this honorable court of the person similarly placed. To maintain parity manners, this order has to be given at provisional registration.
But there is change in situation.
For what is provisional registration?
Circumstances have changed, the main petition order is passed.
Once the act has been repealed in 2008, we are in long-standing possession. My vendors have a registered safety.
You may be having point in that urban land ceiling matter.
Provisional registration is what the honorable Supreme Court
What
has
would
said.
happen now?
What is it?
The main expedition is pending for the Lord status quo. But what our state's contention is, the land is vested with the state. The lordships hold it otherwise. Then my friend's argument would be correct. If the vesting is held upheld by my lords, then they have to necessarily go through the.
Today your client has not presented any document.
No, we are presenting the refusing.
If you present and if it is refused, I will pass orders on merits. Today you are not presented.
It means, what else, after your lordship passed an order saying
same order is a similar batch of matters, my lord. In one of them, this very same person, that Chintar Kumar Yadav.
In Thakur Rupa Singh's matter, that was the direction not to interfere in building construction. It is different.
This Chintar Kumar Yadav, please let an order.
But I am only asking my lords to define by what 2 weeks. Kindly see what the WP number which I gave price to the
Chintar Kumar Yadav.
If the matter will still allow you.
My friend will allow me. Chintar Kumar Yadav, same order he has obtained. Now, with regard to plots which are side by side, so that Chintar Kumar Yadav's matter, that same person has got another plot side to his plot. So, perhaps to maintain parity.
Since 22A petition was already decided. Right.
No, the
Today,
Supreme Court has not said that the moment High Court decides that this direction we are giving with regard to provisional registration.
you may get a better order. Why you want this order?
What I'm not able to understand.
In all other cases, I have passed orders.
But make a small make the matter simple. We are not, your lordship, although we are stating in the in our prayer to remove it from the prohibited list, that is actually not the order we are seeking, because we are asking for the same order which your lordships have given in the batch, which is to allow for provisional registration. Their lordship, the Supreme Court has said, we make it clear that merely because the provisional registration has been permitted, parties shall not claim any additional equity. We make it clear that without express permission from the High Court, there shall be no further registration.
Honorable Supreme Court has also clarified saying that
Page
since
23.
the High Court has not decided the virus 22A, let the provisional registration go on. That is what this category finding on.
Provisional
And
registration.
everything to back the matter, this is the finding of Honorable Supreme Court.
Registration, provisional
Well,
registration.
Differ it by 2 weeks.
By
It will
page
create a lot of confusion.
Page
So you
23.
see, one order, if
Page
we see,
23.
Mayur, 1 minute. If I were to pass one order, there would not have been problem now. Hundreds of writ petitions happen.
No,
If I pass order in your case, I have to pass others back.
No, you have already passed.
I passed before the judgment of division bench,
This was also before that judge.
and that is different. I did not pass any orders with regard to registration. Only for not to interfere in building construction.
No, this order.
Because all of them, that Raja Rajeshwari Society, if I remember correctly, I passed orders.
Same order, which is dated 11th October 2023 by Chintar Kumar Yadav. The same person has got an order. Chintar Kumar Yadav, please.
Yes.
11th October 2023 was the date on which lordship passed this order. I may just read. In the light of the orders of the apex court, there shall be interim direction.
Yes, Mayur, that is pending.
This is 19 day. This is 19 day. 22.
This day, what I'm trying to say, supposing I file a writ petition now, man, that may be a sin. But on this very day, that writ petition which is for being mentioned was also listed before your lordship.
Today, since your client may not be having urgency, you please wait for 2 weeks. Right?
On 11th October 23, his writ was listed along with this writ, man. His writ was listed along with this writ. Now to maintain parity, we can't treat two people separately. Otherwise, all those orders have to be recalled now. If what my friend is saying is correct.
Petitioners have undertaken, Lord, they will not give any equities.
Yeah.
I will now requesting my Lord to define by 2 weeks.
No, what I'm saying is.
Still, Lord, why should the, I'm sorry, Lord, not questioning the court. Or my submission will be, why this order no, Lord? In the deed of division, Lord, I'll be the matter 2 weeks later.
7th October, lordship passed orders on all of them. This matter, which is a foreign mention.
So I have passed.
Yes, please pass.
Not yet. How can I pass now since the division bench pass final orders?
We cannot case an order which is there. Look at it now. That order which was passed.
Mr. Mayur, this is not a complicated matter. ULC issue in several other writ petitions have been taken up by me. I have granted interim orders in many of the cases. Rajarashwar Society, I think I have passed 30 or 40.
In fact, the state stand benefited by one of the petition.
Your relief is different from Madam Thakur.
Session, may I make a comment? We were also saying, subject to what Mr. Prasad says, fellows, now to bring in some sort of quietus to this matter.
if we are allowed to file a regularization petition, because we are in possession of the land. Regularization, they may be.
Let them approach the ULC authority. They have not approached. Let them give the direction to
You
approach.
don't have any time limit.
What I am saying is.
That is the problem. Let this court pass it.
These survey numbers are registered with the state is our contention. When society has filed the request, the lead request, you will be requesting a lot to take up the request. If that is answered, all these applications, the state is ready to consider. They are ready to consider.
You show me if Geo 59 covers government and ULC surplus lands also.
747 and G 435. What has happened in this matter is thousands of applications are pending. If the state has already corrected the amounts, they are not being permitted to issue endorsement by virtue of the status quo order operating the state petition. That is answered. But we release, in fact, the state is not coming forward to word with regularization scheme.
Was the scheme extended?
That I'll answer not to.
It is not, that's the problem.
Because of the status quo operating, because the
If
status
I
quo
got
operating.
You don't have to worry, you can argue on merits.
No, what I'm trying, I don't want to figure out, what I want to do, madam, is,
And
let me submit.
see, Madam argued in one case.
Yes.
AGP also argued. I'm telling you. On Madhapur area, there were several plots.
Yes.
For example, 20 plots are there in the layout. 15 of them have constructed houses. There is no disturbance. Vacant plots, now they are saying this vested in the government. So 1 or 2 plot owners have come here, they have taken building permission. Have granted interim order. So you may also, yours is ULC issue, whether regularization or not.
We may be permitted to give regularization applications without the time.
You show me the geo which is valid
We
today.
can always pass an order, not making a statement on behalf of the state. There are thousands of applications pending, the state is also ready now, coming forward to it.
If you have find to you, please tell me, I'll direct them to process the
No, there is
application.
no expectation at all.
The request of learned.
Like this, we are in possession of the land.
This is.
We have registered sale, we have a previous registered sale deed just few years ago.
Argue on merits. Please argue on merits, it will not take much time. I have decided many ULC matters.
44 also would go along with this.
21.
44 also. Item 44.
No, that's 44, Mr. Vedula Venkatramana is appearing on that
Okay,
is
this
timely.
So informing the court,
It comes with both.
Yes, let
this
us see.
matter, I am requesting the matter to be deferred for 2 weeks.
I'll consider, let the matters reach.
No, this request, that's also there.
Manchirevula, what is that issue?
From 74 to 76, 46 to 46 to 53. But this also, what I will request some time.
46 to 53.
Yes, Manchirevula.
Did I pass any orders?
Foundation. I need to argue this.
2021.
Just 2 weeks.
Mr. Qureshi. 49 is separate.
49 is.
Manchirevula, 7 for
49 is related to Dharli portal correction.
Item number 44.
I think,
No, 46, 47, 48.
Madam, you are here. The court. I will grant.
One small submission, just to what my friend was saying. Yes, let the order of the Honorable Supreme Court. It's a well-established principle. That the points which are being prepared by the Supreme Court in its order cannot be added to or improved upon by the Honorable High Court. What the Supreme Court has said, I just read out at page 22 to 23. It doesn't say that we are making an interim arrangement that till 22 CAP is decided.
Mr. Mayur,
Yes.
please, you consider one point.
Yes, sir. No, they have said two provisional.
At the request of learned special GP, I have posted all these ULC matters. I will decide the lead matter
Also, unless.
All these No.4 matters, I'll decide.
Saying that the Supreme Court says.
See, your client purchase. You have a registered sale.
Yes.
More than 1,000 plot owners, they want regularization.
Well, 90.
The government's problem is, if I pass order here, all of them,
Status quo and operating.
they will say, you give back our amounts.
In one of these matters, the argument that till High Court decides Supreme Court order will exist. That is not.
1 minute, actually, why not? When the matter was before the division bench, you could have requested the division bench, saying that we'll go ahead with the regularization, because the plot owners are third parties.
What happens?
You could have taken that.
What happens if I make a request for an order is passed, then the petitioner will say they lost it.
Now, if writ petitions, if lead writ petitions are allowed, they have to give back the amount. That is the problem of government.
Thousands of people.
And it is hundreds of crores.
What I'm trying to submit is, the Honorable Supreme Court has said do provisional registration. They have not said till the High Court decides. This is something which.
I know, I understand.
My understanding is that.
The para doesn't say so.
We are going to the core issue of ULC.
Yes.
If it is not vested under ULC Act, you don't have to pay anything for
It should
regularization.
be happier.
But till then, let provisional happen. What I'm saying.
If there is any necessity, you are presenting a document, you please come before me. Today you have not presented any document.
That's what the specific statements we have done.
Let it come after 2 weeks.
He's saying, what I'm insisting is, in 100 matters, para 7 has been shown.
Please understand, this is
19,000
Let it come on 21st next case.
Item 11, Mohammed Nasiruddin.
Please, your lordship, I am representing Muhammad Nasiruddin, my lord. The petitioner is the owner and possessor of the land, my lord. To the extent of 4 acres, 0 gunta. And the petitioner is having all the documentary evidence so that.
Who is interfering?
At respondent 2 to 4, they want to conduct the survey. I have stated in my application.
At whose instance?
They are doing, my lord, on 21/9/2023, they approached to the site and they want to conduct the survey. On 30th/10/23 also they have approached and they
Go and
conduct,
file objections. Why are you?
objected and inquiry conducted. They said that they want to allot it to the weaker section. I am in the
Third
position.
learned senior person, Mr. Issue.
Item 12, Mr. Shravan Kumar.
May I please, Millets? Millets, the petitioner being a co-partner to the Hindu Joint Family Properties, Millets, he has filed a partition suit in the year 2017.
File a partition suit by paying 200 rupees court fees. Why do you come to High Court?
Millets, all the survey numbers which are part to the suit, Millets, the respondent number 4 to 6, they are trying to alienate the properties, Millets, pending the suit. Page number 2, Millets.
Not to eliminate, not to transfer.
Why can't you get this order in the trial court?
Millets, there is a difficulty of district court's bifurcation in the year 2020, Millets.
Why do you think only High Court can pass that order and not trial court?
Millets, there is a difficulty, Millets. There was a district court's bifurcation initiated in the year 2020. Almost 2 years the case was held, Millets.
You think only High Court can pass that order?
No, Millets, there is a difficulty. The petitioner is a senior citizen and 2 years the case was held, Millets. Millets, there is a reason due to a district court's bifurcation, the case was held for 2 years, Millets. That was the difficulty.
suit is filed in the year 2017.
Minutes, now this OS number has also reassigned. It's a 201 of 2022 minutes.
It is as good as passing injunction order in partition suit if I pass this order.
No, my lords. It only benefits to block the survey number in order to not to have any transaction, my lords. My lords, page number 19, the old Patadar passbook and title deed of petitioner, my lords. Out of those two survey numbers, one of the survey number has been
Where did you say because of bifurcation of the court you are not able to pursue injunction application? Which paragraph?
Millets, in my affidavit,
Paragraph 5, petitioner being.
para number 2, my lords.
Petitioner by being plaintiff number 2 to OS number 201 of 22 after district court's bifurcation. What are these pleadings?
My lords, it is a case for a partition and separate possession, my lords.
When a party is used counsel to plead. There is not even a single comma and full stop in this sentence. How should I understand it?
There also not stated to pass. Partition suit bearing number schedule.
Who prepared this affidavit? You prepared?
Yes, my lords, myself.
So did your English teacher say don't use comma and full stop?
My lords, my apologies.
Don't say you are from Telugu backgrounds. Many of the lawyers were from Telugu background.
My lords, I won't say my lords.
Which court it is transferred to? New court. Whether in the new court, whose suit number was given or not? Nothing, no details. Petitioner is lacking legal assistance at the district level. So at the High Court level, he has legal assistance. Same lawyer can go to district court. You can go to district court.
Anyways, I'm going to pursue the partition suit, my lords, at district level.
In page 5, it says OS 201 of 20.
Every partition suit, if I pass such order, notice to respond.
Item 13, Madhavi.
What is the title, madam? You purchased recently. Who is your vendor? Nandi Kishore. From where did he get it? 2020. And his vendor? Registered, released it.
Indication is that we are interested in order.
Construction activity, where is the building permission?
Page 52.
52. All are self-declaration.
In first paragraph itself it is stated. Instant approval based on the self-certification submitted by you, and this authority has conducted the post certification TB pass, and it observes that permission obtained by you is found correct, and you can proceed with the next. If
Will you find out?
I'll get it.
They have building permissions. When self-certification is made, don't use scrutinize your document.
Because the TSHC method, whatever online method is a submit method. These are all of method online.
Yes, do they make site visit or not?
Then visit method. Afterwards method. Before that method, I think method. No, because method.
Petitioner.
Item 14, Mr. Ravi Kumar Reddy.
Petition give instructions.
I think this technically, direction to consider the application. Made on lots of the.
For
Share certificate section, family member section.
for family member certificate, do they have to apply to Dharmi?
Online application.
There is one format. Please get the information. GP.
Yes, sir. I'll get it. Online application.
In other cases, you said that e-Seva application.
Yes.
In Dharani portal, it might be there.
Not in the new application. These are not FMC certificate of the.
Friday?
Yes.
Item 15, Mr. S. Sudhendra Reddy.
Similar order? Why are you showing similar order subdivision, please? Justice Sudhir Kumar Swamy.
This is not subdivision, not, this is only a plan application. Not for subdivision.
Let me explain.
When he has not taken objection, why you are apprehending that he will not conduct survey and subdivision? In anticipation, you are asking for an order. Anyhow, I will say, this was the council relied on this judgment. Petition is for declared.
The Mohammedan Srinivasrao.
Regarding the age, early progress of that. The original, what are the father of the character basically asking the order that if the disease is some kind of joint application under section 6 of the new year, that is the procedure on inheritance, getting the rights.
Automatically it will be considered.
That's why
Why are you coming to the court?
he did the stating on page 16 last paragraph.
Is the absence of consent of remaining legal heirs.
They have to file a joint application before the
Joint means according to you, only two or all legal heirs.
legal rights.
Why have you not taken all legal heirs?
Here the legal rights are only two.
Who is our 4 and 5?
After 4 and 5, some construction elements filed an application before the Tahsildar. This is the government land. Please put a board in the land that going to grant any new Padada passport. That is their application. So it means that shows the land is available. The district collector is also repeated that part of the land is recorded, part of the land is submitted. This is not continuous submission. This is the low level area.
It is found that applicant is in physical possession of only some extent of land. Remaining extent was merged in Godavari river. They are not leaving Godavari river also.
That is not submitted. Occasionally heavy floods are there, low level area. That is submitting. After some time it is.
Then again he says due to absence of consent of remaining land, legal heirs of pattedars. Who are the remaining legal heirs?
Only two sons.
2 sons and 1 daughter.
No. 2 sons.
Page 16 it is stated.
Page
16,
which paragraph?
first paragraph. Leaving behind 2 sons and 1 daughter as legal heirs, etc. Application is the son of the official partner. Content of them.
Where is your sister?
They are not.
So if a sister comes to you, what advice you will give? You married long back and you have gone out of the family, you will not get share.
They are not interesting to play with them. Only the 2 sons.
Then take your sister and let them relinquish her right.
After you file a joint application.
So I have asked you, if sister is your client, what advice you will give? You will say you don't have share?
I must say, if I am a child of education,
If you say that, I will ask all MR officers to be furnished copy of Supreme Court judgment. And what Supreme Court said in the last paragraph you have seen?
they are having.
Do you know what Supreme Court said in the last paragraph? Which I may not agree. Daughter is daughter for life. Son will be son until marriage. So you are doing injustice to daughter. How can you say only 2 sons will give consent and daughter's consent is not required because she is married? 2005 Act marriage is immaterial. Notice to the sister party.
Something, Ram Kumar Rao.
Telling that.
To meet our dated 27/4/2021. Page 25.
Shashidhar Reddy. Item 18.
Where this is last. Inquiry by petition for consideration of application raised before the concerned revenue authorities. Delete the illegal entries, cancel the sale leads.
There is Dharni application.
Not the application, your lordship, I am the further and that said member, I am the neighbor of the said server member.
Not only
And then payment has enough.
Taking action of respondents in allowing illegal encroachments, issuing patedar passbooks.
Yes, sir. Kindly see the page number 47. Your lordship. The survey number 168. There is only 19, contains 19
Initial description instead of the 2111. How are you concerned?
in the neighborhood of the others. The subsequent purchases are encroached by land. Out of 19 acres, there is 52 acres. Can you see the page number 64? Your lordship? It is the third.
Item 19. Moin Ahmed Qadri.
Inspections for the state that not, it's approved layout then.
This election policy. Slot.
It is the layout.
Two thousand sixteen, temporary, technical layout plan.
Page number?
So we get funded also.
When you have approval, why will they interfere?
It's what not years. But it is less complaint there. Third party will not maintenance. Say the third party. With the third party.
Petitioner was issued layout permit 2016.
Yes.
Now, after so many years, 7 years you are coming to. Plots converted.
He mentioned the plot numbers, he mentioned
Petition 5-31746 of 22 by K. Venkat Reddy. There was some dispute between these two parties. The court directed for them to resolve it out.
What are your instructions? Yourself?
Expand number 5.
Already. AGP.
In direction, not in the third column. Having a full level, not.
How can I pass order without there being any cause? 2 weeks, let them come. They are saying one plot, owner of this layout has disputes with you.
Third party. Previously, you also filed a petition against this.
Who is interfering? You should say what is the nature of interference.
No, it's similar and along with the.
Correspondent has interfered, and what is the nature of interference? Who came to the site? How was the interference made? Stopping means what? There is a layout. You have a Nala conversion. You have a layout approval. Why will people interfere?
Having all the, let them say follow.
Order cannot be passed for mere asking. If there is a cause of action, I can pass order.
There is illegal that certainly the development act.
1 week, 14/11 motion. Let it come. I will pass and dispose of.
Page number 2, item 20, the free count.
May I please, Miller? May I please, Miller? The petitioner, Miller, challenging the action of the third respondent, Miller, interfering with the petitioner possession and demolished the house, Miller, extent of 60 square yards, located at survey number 334, Miller, Nizampet Mandal and Municipality, Miller. They have issued Patta, Miller, kindly, Miller, page number 11, Miller.
This certificate is experts in another 60 square yards and making a construction of 130 square yards, Miller. In fact, Miller, this Pattas, Miller, issued, Miller, there was a direction to cancel this all Pattas, Miller, because
Miller, they have not issued any notice as on today, Miller. They have directly came and they have demolished the house, Miller, asbestos house, Miller, which has extent of 60 square yards, Miller. Without cancelling this Patta, Miller, they cannot go further, Miller. I am paying property tax, Miller, and also the current bill as on today, Miller.
So since they are saying in the guise of 60 square yards house side patta, you are entering into remain adjoining 60 square yards.
No, Miller, that is false, Miller. Even though, Miller, I have not entered with any other possession, Miller. They have not issued any. If I have entered into the other 60, Miller, they have to demolish that 60, Miller, but they have having no right, Miller, to interfere with the 60
square yards you have utilized.
No, Miller, I have not utilized, Miller. I have having only 60 square yards.
Your client will say that you will also plead the same thing. How will I decide?
Miller, let them not to interfere up to only 60 square yards, Miller.
You have boundaries in the patta certificate.
Miller, they have not given any boundaries, Miller. Kindly see, Miller, page number 11. Uttaramu, Dakshinamu and Pashchimu, they have
132.
no boundaries are fixed at the time of issuing the Pata, my lord. Let them direct, my lord, not to interfere
Lord, you
only
have
to these
occupied now.
periods.
Whichever is vacant.
Lord, they themselves has issued that one, my lord, and I have in my plot number, my lord, 132 only, my lord. I am in plot number 132. It is on the bottom, my lord, 132, number plot 2.
Is the
And also said, the people may not make further.
The TSHC.
But their forefathers, their fathers also cultivated the land. Thereafter, they made an application before the RTO. But for the issuance of warning. This time, only asking to direct to the RTO to GP. Not say, this is the page 13. It has been issued to Sasila to. This is
page
13. It was directed to Sasila to inquire into the matter. It became under the disposal of the proceedings. First one, because this is close to the Khammam town, Soda level.
Why don't you wait for 1 month until elections? They are saying everyone is busy with election duty.
2 months, 2 months.
I will adjourn this writ petition beyond 1 month so that you will get instructions.
2 months. After elections, anyway, they will not want for inspections, not for the meantime. Anyway, they have time after elections.
See, in every case, the application I can understand. If the Zina matters, if we are saying 2 months or 3 months, you understand if I pass 10 orders of such nature, then service of notice will take more than 1-2 months. Is it possible?
They have already received the notices. But they first from July onwards. They also
GP 6 time get inspection.
Item 22, Kiran.
Page 32.
Yes.
What ground?
It's 33.
Same area,
Same area. With last numbers.
similar circumstances ordered in
Was modified. So
nobody
receiver
is
P. Venkatesh.
Provide information regarding these surveys. Based on the resurvey conducted by the third respondent, the fourth respondent has started digging right in front of the petitioner's residence. So there is a washing
in
facility.
action of fourth respondent is proposing to raise a washing facility in front of petitioner residence which is
These survey reports were right. For conducting these survey, they were not put on notice files. The report is also not.
petition. He has withdrawn the writ petition. Again, Mulad has filed another writ petition. There Mulad has sent the municipal corporation parties and withdrawn. There was a direction to approach before the appropriate.
what is the stage of construction?
Digging works are taking place now. That is affecting the
Respond.
sites.
To approach appropriate forum, Mulad, there he was withdrawn this writ petition.
So when I am not in possession of the survey report, my lord, I cannot remove provisions under Survey and Boundaries Act. So she can actually see the photographs. At page number 38 to 41, my lord. Right in front of my residence, my lord, digging works are taking place.
Are you creating artificial lakes? Yesterday I have seen one case, today another case. When there is no water, why are you giving this land to washermen? Where will they wash their clothes? This is in the midst of farmlands. I can understand if there is a lake and you create a channel for water facility for washing. In the middle of farmlands, you are constructing a dhobi ghat. From where will you get water? You can get water, yes. Suppose apparently if they are arranging water, it is different. There should be permanent source for washing purpose.
But base 30 mm, there is water is there. Left side, some water.
It is for this construction work. That water is not enough. There is a house on one side, there is a land on one side. Why are they constructing? This is the second case. I can understand that graveyard and other things, water tank. They are constructing a Dhobi Ghat. Where are the facilities? Let us see map showing so and so.
Affecting these methods, they should have one notice at least the petitioner method. On this HIGHCOURT has
Today you apply for F-line. I direct them to consider F-line pending that F-line status quo will be maintained. Why are you coming? If they have not done, why can't you do it?
I have already filed on RT application.
RTI will not, this indirect.
January itself, the petitioner husband.
See, without claiming direct relief, you are claiming information indirectly. Why can't you claim substantive relief?
Page 42 minute times. Sketch.
Yes.
Survey number, boundary, existing road, proposed for Dhobi Ghat, 1000 square as mirror. This is a road mirror. This is a road mirror. After that road mirror,
Social welfare measure, courts cannot interfere. For washermen, they are doing.
They should have put me on notice, madam. So this honorable court, lots of kindly go through this.
Second by it's a 3 section. 14 level motion.
Status quo.
Yes, let status quo be maintained in state of hearing because once it is changed, the nature of land is changed. We cannot do anything.
it is showing the road mirror. Before the road mirror, it is not the part of the physical land. It is showing the road and left side road, residential mirror. Land itself it is showing mirror.
Because all those books and equipments are lying, madam. So for my portion, I have obtained.
Without filing objection to the survey report, you are directly coming to this court. How will I decide title and possession?
That is my difficulty, madam. I am not in possession of survey report, madam. They have not put me to notice at all. If not, may kindly see this order or by this honorable court.
Status quo obtaining as on today.
Item 25, Annapurna.
And also, Mandala has to also is at page 25 or also finds. If the absolute owner may not, there is.
Page 20.
25, Mandala passport has been issued there that he has purchased the property in the 2012 and the deed of the property. 98, when attached deed of 4 acres technically password, page 25.
Why don't you give the description of land in the prayer? Why are you only saying survey numbers?
The last week I letter has been issued, notice has been issued on 21st October, saying that there is a land, pathway passing through my land, that they are going to conduct the inquiry and we must wait for that. They are strictly that in enforcement for the issue, 2021. The page 36, page 36 is the enforcement. Based on this enforcement, they say that there is a pathway to my land, on that page 36.
This 2021 document.
Yes, based on this endorsement, now they are proceeding by issuing the notice on 7th October.
Respond, you are for?
Item 26, Palasri Anna.
The account for that for getting names of the additional from the revenue records. These are owner was of the land for.
Restore the name of petitioner.
You are asking.
Notice to respond.
Item 27, Mr. Venkatraku.
Jawaharlal. When is the batch coming? Batch. With the Jeep.
Item 28, Prashant.
Please, Lordship. The order was passed by respondent number 2 in the Maintenance and the Welfare of the Parents and the Senior Citizens Act of 2007. By challenging this order, I have been approached this honorable court. Lordship, the application itself, the section 4 very clearly says that.
Low down your voice.
Okay, Lordship. Lordship, the maintenance.
Wait, this is the lower voice. Still low. I don't have problem, all your friends are.
No, nobody is talking.
Yes. You had training on political platform.
Voice like that.
You can lower your voice. You cannot speak in low voice. One minute. Petitioner is daughter-in-law.
No, daughter.
Daughter. What is the relief asked? Both father and mother were.
Yeah. Please, Lordship.
Sons are not there?
Not there.
First time I am seeing parents filing against daughter. So let us see the interesting case.
Please, Lordship. Lordship, I am the petitioner here.
I ask you to lower your voice.
I am the petitioner approaching this honorable court.
1 minute. Ramchandran, son of also has filed a case against daughter-in-law and son-in-law. Why son-in-law has come into picture?
Yeah, I will tell you.
By order.
Daughter and son.
SHO Alwan police respondents Suhasini occupied her parents' house. What so shall vacate the house within 15 days from date of receipt. Where are your parents staying now?
They are staying at Warangal, sir. My place is different. I am having.
Where is this property?
This property is located at Alwar.
Alwar.
I am having a.
I passed another order saying, GP, you remember? Property in Hyderabad, parents are in Warangal. Another same case. Not this case. Parties are there.
Respondent number 7.
Do you have the complaint? What was the allegation?
Lordship. The allegation of Lordship, the 7.
It's when you are staying in Hyderabad.
Since from 2015, Lordship.
15. Yes, interim suspension as prayed for.
Item 29, Mahendra Reddy.
Son and daughter-in-law? Son and daughter-in-law. What was the relief asked? How many children they have? One son. With one son he is fighting. Daughter? Without daughter, I can't believe there can be any case. Then what is the grievance?
To make it for the petition of supplement.
The dispute is between daughter-in-law and in-laws. Where are the in-laws staying now? And you are? This property is in LB. Who is taking care of parents?
He himself is taking care of
Is he a pensioner? From what is the source of his livelihood? You should get all these instructions from your client. What is the issue involved in senior citizens matter? Maintenance and ill treatment, that's all. He is getting.
His father.
Then why did he file against son and daughter-in-law?
He wants this.
Why lawyers are not filing this complaint? No one is filing the complaint. These orders are passed in just one paragraph. Nothing, no discussion at all. Unfortunately, I don't know whether they are doing justice to the senior citizens or interim suspension as paid for notice to respondent number.
Mr. P. Venkatesh.
Pursuant an order of collector, asked under section 32 of the NCI, mutation application was made by entering the names in the response 57. 32 my lord. Landlord has filed a petition seeking possession from the tenants.
Landlord filed a petition.
That was allowed by the collector. It was rejected by the lower authorities.
So you should go on record. First time landlord filed a petition for recovery of possession.
Yes.
A tenancy act. You are the lawyer. Always I have seen only tenant.
Yes.
Landlord's petition was allowed.
Allowed by the collector.
On what ground?
Yes. The ground that they were.
Tenants have not remitted the amount. Only one ground.
63.
I have seen cases arising under Andhra Tenancy Act.
Yes. Not
Telangana Tenancy Act, which landlord will go and claim that, admit that tenant is there?
In this matter, they are fighting rejection petition in the year 75. There they failed.
Possession delivered?
No, not yet. I filed a CRP that is pending now. Personal can see page 63 of the order. Operative question there in the.
Then without possession, why are you asking for Dharani?
They have asked me, response 7 and 8 have got their names mutated.
Respondent 7 and 8?
Yes.
Who filed CRP?
CRP, the next file, I am appealing for the tenants.
You are the tenant.
Yes. I am appealing for the tenants. My CRP is filed, that is bogged down in this order of the additional collector was passed against dead persons.
Possession not delivered.
Not delivered. My difficulty.
How will they alienate them?
Once these are recorded in Dharani, potential litigation of alienation. I only want that aspect to be protected. My CRP is pending. Personally, can you see the order please?
I will grant him notice to respond.
Item 31, Mr. Yogesh.
Why? Revenue entries changed? What relief I can grant today? You should have asked for another relief then. I said you should have asked for another relief. Should ask for direction not to alienate. You will find now. Is to respond. In other case also you did the same mistake. And now you are saying, that's why I said it has become a tuition class. 1 week back you did the same mistake. What is the difficulty in filing second application?
Item 33, Mr. Tarunji Reddy.
Also, having to a lot, interfering with the petitioner's land, excavated the unit. Without issuing a notice, without following the law. In fact, in the year 2014, it's petitioner's neighbor was there, who's the petitioner's husband, FTL. They claim it for FTL, my lord, because, my lord,
Would like to see the possible in the matter.
identical matter, my lord, models passed where they claim, my lord, that this land was an assigned land initially. The assigned land, when they claimed it, my lord, this honorable court passed orders stating that no, it is not assigned land. They've taken this in SLP and SLP is pending. Identically, when they sought to interfere last time, your lordship will see the interim order passed in the last interim order, page 31. This was in 2014. For 9 years, they remained silent. No notice issued. In fact, we have been.
What are you doing in this land?
No, it is my land, my lord.
What is the activity there?
My lord, empty land. There is nothing there.
If there is empty land, status quo order will be
Yes,
there.
madam.
But we like to seek a possible in the matter. And it's coming under the petition.
Status quo will come.
Yes,
State of benefit.
There is some referral.
Passover. Passover.
All three will not assume.
Item 36, Ratangapani Reddy.
Miller order. 20. Many contracts your client has. Yes, madam, I thought your colleague is appearing, I didn't see him. So I was asking him how many contracts he has. In similar circumstances, order dated one.
Item 37, Karthik Naik.
Replacement.
That his petition filed below challenging the action of the respondent number 3. Rejecting the actual application below the absence of the selected candidate.
RTA.
Page 24 Millard, I am representing R1 to R3 Millard, stating that with the reference of the application under the reference cited, I have to inform that under section 8.1 of the Right to Information Act 2005, the information relates to personal of the candidates. Hence, the information of the certified copies could not be provided. The selection list Millard, as per the notification Millard, stating that as per pharmacy grade, page number 14 Millard, notification multi-zone.
Get in file counter.
Yes.
You are not selected.
That is the.
Why can't you challenge selection? Why are you coming through indirect means? Why you want information indirectly when you can get it directly?
I suspect that some non-local.
When you file writ petition, they'll give you information about the qualifications. What is this post?
Pharmacist.
Pharmacist.
Yes, page number 12 Millard, pharmacist 5 vacancies Millard permitted.
According to you, they don't have qualification.
Yes.
All of them.
Two candidates have selected from the non-local.
What is the basic qualification?
Pharmacist, bachelor of pharmacy.
B pharmacist.
Deeper.
D.
D.
You are for
1 to 3 Millard.
motionless. In all service matters, everyone files the RTA application. For pension, you are saying, how did you calculate, give RTA information. Here also, when you file writ petition, you will be given information in the form of counter affidavit.
Moreover, Party made a party for the information. What they ask.
No, here at least this lady has interest. Here, in other cases, they don't have any interest. The candidate who was not selected is coming to the court. Not required.
Yes,
Others are
have
not.
to get instruction.
Because it is not personal information. How it is personal information? Only educational qualification.
Item 38, Thakur Rupa Singh.
Property of 2,100 square is a Shira Nagar, Kotapur village, madam.
Same, madam?
It's not same, madam. They are referring to paragraph, if your lordship studies paragraph number 2, they are referring to survey number 205. Whereas they are relying on a judgment which is.
I passed order in Raja Raveshwari colony.
Only the thing is the locality is different, my lord, like the Devati.
If I remember, it is
That's not separate village, my lord. That's all Kondapur. The
arising out of same declaration, ma'am.
I have passed on the instructions to your lordship. My lord, is this?
Yes, V Sudarshanam, that survey number is coming under 200, my lord. But the reference of the relying judgment is relating to survey number 77 of Kondapur. This is 77 and this is 200. If your lordship perishes my instructions at paragraph 6 of my instructions, my lord. The repetition, which is the main repetition for this Sri Ram Nagar colony, my lord, is.
Building permission was revoked.
Yes.
Final, it should be final case, madam. Let them file counter.
Yes.
How can I allow the petition?
The same order I can present it tomorrow with regarding to Sri Ram Nagar colony.
Was any interim order passed by any learned judge suspending revocation?
Yes, sir. I produce it tomorrow.
To
Which
which
are
I am not
objective
aware,
to
madam.
the-
My instructions are.
If they are objecting to the covered matter which I have submitted, then I will give another copy with regarding to the Sri Ram Nagar colony which has been passed.
Why have you not enclosed that order copy?
This is the recent order. I thought that it will be applicable.
Page number 3, item 39, Nanda Krishna.
This is a case where my grandfather had given such a land for laying of road was for 3 decades or 4 decades back. Now they are extending in the remaining portion of my land by extending the land.
I have come across number of cases where grandfathers liberally and generously donated about 50 years back. Because they had surplus land. Now grandchildren are coming and saying my grandfather has not donated.
No, I'm not disputing on the existing land, but on the extension of land, they have to ask question. In the recent case, my lords also observed on the same point. In the last occasion, I had the advantage of sitting in this honorable court. But my lords observed there cannot be any grant of 100 feet road in 30 or 40 years back. So,
Material placed on record received for several years. Physical status of the land is shown as PWD.
in this case, my lord, there is
Counter fine.
One second. One second. Interim status was granted, and then this honorable court has made the order absolute, finding that there is no nothing is filed by them. May pass up the
Want to argue the main case?
Yes, sir. Well, as we dispose of the expedition on the millers, it's already.
Yes, madam, you are ready.
No, your lordship will grant on it.
Miller, this it has come up quite number of times, and every time that an adjustment is because is that. I think my lords, I cannot come in the way of my lords.
Best of luck.
14, Surya Satish. Item 41, Mr. Ramchandra Rao.
The respondents request several steps of the judicial reform. And they have filed a suit for partition, where state law 2009 before the construction, then it is a general district.
Respondent counsel. You are Ramchandra, right? Respondent.
Super partition is coming for arguments. Father died was the defendant number 1 in the suit. And the respondents 6 and 7 they approached the Tahsildar and got mutation. So they could have waited for the disposal of the suit. But then the argument said the suit is pending.
Suit
for partition and subject. The states are settled now as per the judgment of the finality of the court. So each of the party can approach the Tahsildar.
And you have phone number of the live counsel. Inform if she is here, I will
call.
Also.
Item 42, Mr. Rahul Bhatt.
R6. Omula Prasanna Kumar. We have phone number, please call. Also.
Item 43, Mr. Narendra Jha.
What was the order passed?
Any alienation will be subject to outcome of the request. But why it's an abuse in the law is because he's filed a suit with the same prayer. Suit gets dismissed, files an appeal, appeal is pending, he files the same prayer the requisition gets filed. I just show logic on the face of it, how the same prayer has been asked.
Both the parties here were parties before civil court. Suit for?
Milord, so there in the suit for
They stated that Milord page number 57.
I'll just show you logic. Logic is the prayer on the repetition. Even that no question. Lordship will see the prayer, my lord.
Did I pass any order?
Yes, the difficulty now with that order is they are coming.
I did not say anything. I said any alienations?
Yes, no. Difficulty with that is today they are erecting boards in front of our construction that is happening, saying that just pass on, my lord. These are the public notice that they are issuing and keeping, my lord, based on this order. Which the writ itself is not maintainable in my tent in front, my lord, and this is
how can you keep this board? This has got a bigger impact than my order.
But in fact, my clients wanted to.
I don't understand. People have become so. Why, from where they are getting these ideas? Such a big board.
Yes, and my lord, it also reads, filed a writ petition before the Honorable High Court, have all given order subjecting any alienation of our share of the property. That is what they say, my lord, with this big board. They erected tent beside that, and they stay there. This is the.
Where is the order?
The vacate also has been filed.
A3.
You purchase from the defendant.
But what happened was, originally, the defendant was there. He had entered into an agreement, say, with my vendor. When he did not enter into a sale deed, my vendor filed a suit for specific performance. Decreed, yet when he did not comply with that, he filed an EP, which was allowed. And my lord, a sale deed was executed in favor of my vendor. My vendor then executed a sale deed in my favor in the year 2003. Subsequent to which, my lord, I came into the picture. He, my lord, has filed a suit challenging the old decree in 2008 of 1983 and my sale deed also, my lord. But in the year 2016, he filed that, my lord, and that suit, an order 7 rule level rejection of bail petition was filed, and the suit was rejected, against which he has preferred an appeal also. The prayer, my lord, while there are other prayers also, the prayer, insofar as the writ is concerned, is the identical prayer that is there in there. Page 93 of the writ. Page 93, if your lordship. Lordship will see C, directly.
What is your client's name? You are for R5 to R8.
No, no, R6, R6,
R6 and R6.
yes. We were R2 and D2 and D3.
Where is the judgment?
Let's find along with the case.
Your senior is there? Pass over.
Item 45. Chalpat Rao, DV Chalpat Rao. Don't take action.
Item number 1 and 44 go together. Mr. Weaver is appearing with my set of.
Let the senior notes 231. 46, 45.
But this justification is quite agreed by the high action of respondent number 2 and 3. Interfering with the peaceful possession of the petitioner's land. What the purpose of construction of go down for respondent number 4 without initiating any land acquisition?
Counter file.
In similar manner, in neighboring rights, approach of this.
Sir Chalpati Rao.
Yes, please.
Since 2020, you don't have an interim order.
Yes, my lord, but the thing is, what happened is at the time of filing of this petition, I could not file the Patadar passbooks and.
What is the nature today?
My lord, as of now, my lord, there is no construction because of the interim order passed by this honorable court in the neighboring rights petition that is filed before this court.
Description is telling.
Yes,
Same land.
same survey number. 161 by 2 by 26.
So far counter.
Amendment
I have filed additional material paper.
Why did you file IA2?
It is
For what?
one is for amendment petition. The name of the fourth petitioner, my lord, is wrongly typed.
Application in IA number 2.
161/2. We are constructing 161/1. Identification of land itself is dispute.
For 3 years, if you have not filed counter, what can I do?
Then what we are going, we are making cover.
Today, so according to you, after 3 years, I cannot pass imprimatur.
Not saying that, my lord, but in view of this order, my lord, if any construction is not, my lord, it's affected, my lord. Because, my lord, the identification of.
It is important, you should file counter.
You must have received, my lord.
There is no construction.
2 weeks not anything, my lord, will file a counter, my lord.
What is the survey number claimed by petitioner?
161/2, my lord.
What is the construction is taken up in which?
161/1.
161/2 by what? And 161/2/2.
I am recording the statement.
Yes.
Saying that there are.
Because our government tax are extended to 161/1 as proposed for construction of the marketing board is situated adjacent to the national highway. And
When did you receive the instructions? Which year?
dated 1/11/2020.
Until today, no construction has been
It
undertaken.
is representative. It is representative. Post along the.
Item 46, 47, 48. Mr. Kautur Pawan Kumar.
They filed interpret.
Uncharitable covered matters.
Interpret, they filed, they have withdrawn the interpret.
I passed order.
Lordship's only law passed order. They filed a review. Review was dismissed. And my only endeavor is, one more matter is there.
Where is the judgment of Justice Navin?
Before that.
One land ceiling, madam?
Yes, yes. They filed a review. Review of justice. Writ appeal was withdrawn by them. Writ appeal also filed.
But this Hyder Ali Mirza,
Yes, yes.
dead person.
Yes, I'm a dead person. Kumar Kunad along with that, Richard Matt is there, is at 2019. Now roast is before his lordship. That matter also being done because the lordships are having roast up together.
I'll pass orders in this case, show it to another learned judge. Why you want the matter? Because 2019 I am not having it.
That is there. The lordship,
You
lordship have the doctor so that can, because matter is your same charge.
Sir, allowed, you want to challenge time?
But these matters are shifted to the application of. To adjust this matter for him to come and not you. It's affected and ask him.
Review dismissed.
What stands without being reviewed, but then nonetheless, the submission was made in the morning.
Request for Lord Special GP. Go and give a letter to the registrar judicial. He will do the
Registrar may not, unless you not submit the. Unless you.
When do you want that? 2111. Item number is 46, 47, 48. And
53.
yes.
And you that number also, 2019.
Please give the letter.
Request chief not.
49, madam.
Item 49, Mr. Qureshi.
Your Honor, I am appearing on behalf of Matin Qureshi, Your Honor. Your Honor, in the last occasion, this court is directed to submit the application copy of Dharni portal.
Where is the application?
Your Honor, it may be disposed of by connecting by only for the consideration of the application, Your Honor. Already the part work was done by the CCLA, Your Honor, which is in page number 32, Your Honor. It is pending at collector only, Your Honor.
What is the extent of land involved?
2 acres, 7 guntas, Your Honor.
This number? You have sold the land under agreement of sale from GP.
Yes, Your Honor. The sale deed was also there registered, and in Dharni also the name was mutated, Your Honor. Only the khata number change is there, correction, that's it. Already Dharni also.
I am saying the petitioner has sold the land.
No, Your Honor.
You are the vendor. See page 22.
It is in the name of Darshan Singh, Your Honor. After that, the another sale deed was executed, Your Honor, which is in page number 14, Your Honor. Vendor number 2, Ravinder Singh.
Same land. Have you seen page 22?
Yes.
Page 22 is the vendor, and he becomes purchaser in page 14, sale deed 14.
Your Honor, it may be disposed of as per the direction, Your Honor.
Village.
Your Honor, in page number 32, this is
Password. Other matters will be taken up. Continue.
which passed with the artist class. And if the position here, that is the fine. There is some issue with the settlement. So, it is the unofficial respondent was granted with the land by the IAC. Then the revenue officers has acquired the land. In fact, remains that we are in the question of this. The Sagar report directed the district collector to conduct the inquiry and pass the order. The inquiry, the collector has passed the order, stating that I have entitled for the compensation. Where we are raising specifically, no notification has been issued, and we are in the question.
Land handed over to the pharmaceutical company.
What they said, what is the we are in the question of the property.
Where did he say?
Page 70. That's what submission biology is.
Ex gratia.
Yes. They are admitting that we are in the bonus of the property. But they are saying that the compensation along with the interest. There is no notification issued, there is no procedure has been.
Paid or to be paid?
No, page 17 it stated the court correspondent is IAC. Authorities are instructed to deposit the required amount on permission proceeds from the property.
Page 17. Page 17, paragraph 3.
TSHC in the year 2008.
Right.
Lord, the cannot disturb the position of the consent violating legal error in subject lands allotted to them by TSHC.
No, that's not my position.
It was possession taken.
2008.
The last kind of page 28.
There is no dispute.
One minute.
In page 17.
1 minute, sir. In my case, let me submit, sir. My case is let me submit, sir. I have paid for the. Last me take page 58.
So GP should not.
GP also paid.
I have asked him doubt he has raised.
Sorry. What happened? What they said, 2008 itself they have taken the question. Last me take page number 58. The revenue inspector has written a letter to the Tahsildar Mulugu. The concluding paragraph. Page number 58.
According to when possession was taken.
So, we can see process on Kumari Parliament City of Montecarlo, Kumari Sibaya, Kumar Malik Montecarlo, Pata, Utta Kaliguna. So, we are in the position it is a revenue inspector report to Tahsildar in the year 2010, 25/10/2010. What they say is from 2008 itself, the position has been delivered. In the date, we are in the position, even lordship, the earlier order also, that has been granted by the Honorable Court. We are able to prove that we are in the position of the property frame of this. And now also what we are, the interim order, what we are saying, England is not to disturb from the position. Suspending the order of the district. The lords of the state. Just maintain the status quo, and we are in the position of the property. It is not in dispute with the children, they are not standing the purpose. Can you the team of 3 acres each will.
When was the resumption taken?
And if you know page number 17, the paragraph except to that further it is clear that an extent of
From where did you get 2008?
there is no dispute that physical position of this land was handed over to TSHC in the year 2008, and in turn TSHC has handed over the complete land to biological instead. And also in order dated 28/23, to mention that the petitioners are not filed any documents so that they are in possession of the property. Considering the proceeding dated 1950, the court by order of the petitioner level directed the response not to dispute the subject property without calling due by the law. Clear on photograph filed as a picture as shown would show that the petitioner have misused the interim order granted by this court in the expedition act. So reading of the expedition are translated in one hand, and they have stated that after the demand of the father, their names were recorded in the revenue. On the other hand, they have also stated that their names were not entered in the revenue on the ground that the government is intending to acquire the subject land.
It is not getting the names. Because definitely we have to put down the price. Last week, kindly see page 15 million, the order passed by the collector. Where our contingencies has been raised. The last week, see, the ground two got their raised for the district collector. The government did not issue any notification for acquiring the subject lands. As such, Any transaction or sale is executed by the AP.
I will direct them to pay compensation under the old act or on the new act or ex gratia. Go to page 14, last paragraph. They have handed over possession to this pharmaceutical company on 18/10/2016.
Yeah, without there being.
Without there being means, there are two things. Before disposition, if you had come to the court, I would have granted
There
interim
is a
order.
position right now, what we are saying that, while the document will not be kindly see the paper document.
Mr. Vijay Kumar, this is not the first round of litigation. You have come here. Order was passed, inquiry was conducted. Now, going by the inquiry, it reveals that land was acquired. Whether it is legal or illegal, we do not know. Land was acquired by passing resumption orders. 2016, 18/10/2016 possession was delivered to this company. So today, how can I pass interim order? I only direct them to produce resumption order and ex gratia.
Without there being any petitions and order the 5 months down. The affected parties, they can resume the land.
Mekala Pandu's judgment is there. Let us see. If they have not passed resumption orders and not paid basic compensation. Yes, from where? When were the resumption orders passed?
It is also stated that payment of expenditure total.
Then why did he say?
Expenditure was not paid only to an extent of 60% issued from the assignee.
Page 17, first para, read it.
Along with 9% interest first year and 50%
Under the new act, will you pay ex gratia? Will you pay total compensation? Yes, as a GP, you should answer. You cannot be silent. Under the new act, will you pay ex gratia? Will you pay total compensation? Answer. You are having 2013 Act. Mr. Vijay Kumar, when you are arguing land acquisition matter, you are coming without any act. Read section 3R clause 3. Yes, please give it to GP. I am supplying the books. I will do that. From tomorrow onwards, I will keep 20 on the right side, 20 on the left side. One to petitioner, one to respondent. I will keep on giving the books to you. What did it say? Will you pay ex gratia? Will you pay full compensation as a owner having full title of the property? What did it say? R2, clause 2. Landowner definition. Did it? Yes. Any person who is granted So you have to pay compensation as if he is a absolute owner of the property. Pay that compensation. Mr. Harish, you argued earlier. See that? Unlike Bekalapandu also, actually, according to me, no one has understood it. Right spirit. I have to look it again. Larger bench never said they have to be given only principal component of compensation. They are entitled like any other title holder. Where did High Court say only you pay principal amount and not interest and solation? Which judgment said that? And you anyhow now forget about the old act. See, read the new act. I am going by your own. You are saying you send proposals for ex gratia now. So till now you have not.
There was a dispute between.
Today is not paid. If you have not paid before 1/1/2014, when did the new act come into force? 1/1/2014. So he is entitled to be paid under section 24 of the new act. He is entitled to be paid.
Not but the petitions were pending, not something.
If it is, if status quo stay is there, that time has to be delayed.
Again, it was
Not in this case.
I cannot grant any interim order. I will direct them to initiate proceedings under LA Act. Let them get instructions. Today I cannot grant interim order because after 7-8 years, I cannot disturb possession of this pharmaceutical company.
As of now also,
I have to go by record. Inquiry is conducted. How can I disbelieve collector's inquiry?
the revenue inspector report I filed. Collector who will be receiving end will.
There is a Panchanama conducted and possession delivered.
Yes, Miller, that's why you last in the page 58 Miller. 58 is the report by the Mandal Revenue Officer to the Tahsildar Mulu. 2010, what they say 2008.
Page.
2010, payments of 58.
Why are you referring to 2010?
They say that originally taken from 2008.
Go to page 14, 2016, 18/10/2016, physical possession was handed over. So and so Biologicals Private Limited.
That is the contents. My line item.
No, not for this petitioner. His name is Narsimlu. See, for who is, where is Malaysian? Serial numbers 1 and 2, page 16. Resumption orders passed. Where is resumption order number 3? Not there. Number 1 and 2, it is there. 9/1/2014, 9/1/2014. Same resumption order is not there. You are saying submit ex gratia proposals. In one way, your client is lucky. He will get compensation under the new act. Others got compensation under the old act at the rate of 2.5 lakhs.
State of the land is 3 acres, 3 acres. But in the form B. Now they are coming 2 acres. But
according to county department.
EGP revenue.
One, two, three, four. Mr. Sign up.
Was a motion listed at the request of the Learned Standing Council for SCCA.
Item. This continuation. Item 33, 34, 35. Taranji Reddy.
Let's see. This make a fact. The petition will not be given. And by virtue of a registered CID in 1989, even up till today, when the ownership possession does the record of initially, the government stated that this is not, this belongs to a assigned land. Then it came to be filed, all were allowed, pending with Supreme Court, challenge from the government. We have given ownership and possession. In 2014, when they sought to interfere with that, this honorable court maneuvered in respect of the neighbors, the petitioner, who is the husband of the petitioner. Interim order came to the passport status. Now, from then till now, they do not contest. 9 years down the line, today, without a notice being issued, they come into my land and they state that this comes under FTL as well as land that is site. Therefore, we want to take over that's coming to the GP. One last submission is, in fact, at page 37 and 39, my lord, in 2019 itself, we have issued representations also. Lordship will see page 37.
Why have you not applied for the passbooks?
No, the record is updated.
Passbook, if you have not applied for passbook, then court has to presume that you are not cultivating the land.
He has a claim, not even going on that aspect. He has a claim.
Your name is there. His name is, petitioner's name, her name is there. In convention, this land.
Yes, madam. Yeah, that's right. But there is really, there is no FTS of the particular. There is about 16 itself, this bank was.
Here in convention, there is a time.
Yes, the time only. This is.
In convention comes in column.
Column. So this tank is about 29 acres. Well, this tank was surveyed 50 years per feet. They have about 60 itself, they issued Supreme Court and now party notification. All the notifications are uploaded in the data. Correct. A land is clearly falling within the HTL. Correct. It's the honorable court, Passport Merit passed the orders, directing us to fence all the FTL land. According to the order, yes, now. Now we are taking steps to divert the drainage water by laying pipeline in the FTL area. supports my case. Point number 5, if you concerned. We need to issue notice. We pay compensation if really it's a private land. But when we are disputing that it is falling within the HIL area, it's covered by tank, it's given. According to my section 24 of land revenue act, it is specific state automatically.
24.
Yes, section 24 of land revenue.
Where water is there?
No, not on my land. I picture what they have done with my recently. They have tampered the FPL level. They have raised the soil level. That's what I am on the control. But this is not on instruction. I'm saying. On instruction. For 9 years, we did not interfere. That's a different thing altogether. Now situation arises like this because we wanted to divert the Chala, drainage water into the tank. That is why we have laid the pipeline. Now, if your title is then you are entitled for the compensation, but now you can't start laying a pipeline because the FTA. This here point number 5 regulations clearly stated that when we are dispute that proper remedy for them to approach HIGHCOURT.
How can you lay pipeline?
Yes,
If water enters their land, I can understand.
Clear my land, but they raised that FTA levels. That's what my case is.
What did you do then on these days?
Overnight, they are dumping something and they are more successful. That's what my case. They just raise the level and they are putting the preparation there to establish their possession. But we have actually we measured this FTL according to the FTL boundary. Their land is clearly falling within the FTL. And earlier also, the Telangana people filed a case before Honorable Court. The matter, only the last the case. They challenge the FTL boundary of this tank. And after that order only, they have the FTL survey in their presence. That report was uploaded in the HMB website. As on today, the notifications are still subsisting and no one has challenged the same.
What about status quo to be maintained?
So what will happen? The entire work will be stopped. As of today, this already is being laid on this survey. Already, one survey number we have completed the work. If status quo is given, if work is stopped at this particular place,
the land is coming under submerged. It's planned for water, I can understand. But if you are making any development, that means you are trying to enter into their land or disposes them. For that you initiate.
But in my clear case, their land is falling within the submerged area, but they cleverly manipulate the FPL level by dumping. For that matter, they are having they are going to take separate action against them. But as of today, I agree that they are in possession. But possession means they are not having any permanent presence, they are not having any possession. The title is still pending before Supreme Court. Supreme Court recently passed an order from judgment in separate case in the thing that matters relating to water bodies. Parties, private parties have to be approached compulsorily comprehensively for not under Article 250, the right companies decided that the order also mirrored at the right now, even according to this the judgment also mirrored. When we are disputing, may read this paragraph for 5 minutes.
What is the work now undertaken?
Pipelines, but the pipe picture. Pipelines that day as of now can change. I just passed. I keep Right, so 5 here, no water, nothing. Thereafter, again, they'll cover the pipeline with soil. So that way, they don't face any problems. Right now, already they have dumped all the material also, I have to say photographs also.
This is for diversion of
drainage water. Because drainage water now going with the water tank. So, that the clean water now we are laying pipelines every time.
Even undertaking that you will acquire the land at least to the extent. No, remaining extent not covered by FTL and not being utilized, I can understand that we'll decide later. But this land which is being taken for this drainage pipeline, that means you are acquiring this land.
Main priority, there is no FPL boundary. FPL survey was done, boundary survey, and this particular piece of land. is-
Even in FTL, my question to you is, even in FTL, how can you lay drainage pipeline?
It's not, the state automatically means that the all full tank levels are by the state. The government land.
So according to you, apart from water submergence, it can be used for any purpose. So you can raise a building, you can construct a is only for that purpose. Water.
Yes.
If only water is there, whether it is streams or lakes or rivers, so and so, okay. But he is the patedar today. You are laying pipeline, that means you are taking his land without due process of law. If water is there, I can understand. Today water is not there, or is FTL limits. Yes, he cannot do anything, you cannot do anything. Underneath.
After laying this pipeline, but again they'll put soil and everything will be normal fine.
Do you think it is, they are not deprived of their land if you are constructing?
They are claiming this land as FPL land, right? They can't develop this land in any manner.
They can't, yes, I understand.
Yes, then right now, my lord, they're there in the open land. This will be there as after this work is completed, my lord, that is actually. My specific contention is they are doing this to extend the FPL and does not come within the FPL. They have not issued a notice to me before coming into my property. No notice was issued to me even when they conducted any FPL survey. In fact, my lord, the letters that I sent to your lordship is asking them to conduct a survey. They choose not to do it. No notice issued, and they come into my land. Let there be a status quo. Even I won't do it. The year 2014, but the first they have conducted meetings. Here now they are all doing from online. Every time, every person comes and say, ask for doing FPL for them. Only then we can do that. There's a difference between. And my lord, now everything is online. Everything is uploaded. Everything is uploaded with pedestal maps, with measurements. Everything is there.
What is the extent of land?
About this land area is about 39 acres.
How much extent of land is utilized for this drainage pipeline?
Also state my number. So you can see page 31, same survey number, land adjacent, the status quo. They cannot validate it otherwise. I can't be, my lord, no notice being given to me. Somebody comes on my land, digs it, and then says they will put it back, my lord. This cannot be the basis, my lord, for me being being disposed. One other thing I'll show you, lord.
If it is from the middle of land,
my lord, once again, lordship, I see page 31 for a moment. The reason I'm stating that their entire attention itself is wrong is my neighboring land, which they are doing, which they claim now, my lord, is part of all of this. There is a status quo. There's a prevailing status quo of this honorable court. So, my lord, if they are saying they're coming through my land, in entire area they are doing, there's a status quo of my neighbor's land. Lordship, base 31, one order 33, second order in the year 2014. And my lord, the order they are relying on, my lord, is an order of 2016. From 2016 till now, they don't issue me a notice. I ask for a survey to be conducted, they don't do it. And now, my lord, they come today into my land and they want to dispose this. I only say this, my lord.
yes. No, you please answer his point. He is saying from the midst of his land you are laying the pipelines. Please dispose. How can you say?
He is not disposing.
What else it is, whether you admit or not, it is disposition only. And these are the pipes are so huge. What will you do with that bit of land, what that stretch of land? Suppose he has 4 acres, from the middle of this land you are laying pipes. What will you do with this land? Will you lay pillars and construct 50-story building? FTL is different from laying drainage pipeline. There should not be any confusion.
There is, my lord, separately. Otherwise, we will kindly keep this started tomorrow and place all the critical points.
I'm presuming it is FTL. Still, how can you lay pipeline? Tell me.
But all FTL areas belonging to this tank, my lord, including this FTL element, declared that like 29 acres is belonging to the tank.
As was section 24 of Land Revenue Act interpreted any time so as to be understood that it will be vested in government for all purposes.
All water bodies are.
Do you know in the village, once upon a time, Madhapur, Kanamet was agricultural land. During this Kharif season, when the land is submerged, they will not cultivate. During Rabi season, they will cultivate. That is the purpose of FTL. Today he is the Pateda. So when you lay drainage pipeline, you have to assume during his grandfather's time he used to cultivate. Just because it became urban property, will he be deprived? Can you stay? Suppose if this land was 50 kilometers, 100 kilometers away from Hyderabad, it is agricultural land. What would have been your argument? So you tell me, if it was 100 kilometers from Hyderabad, with agricultural land, you are laying drainage pipeline. How is interest be protected? There is same. FTL Shigam is same.
FTL means water body.
Yes, for water body you use. You are using it for drainage.
No, not we are using, my lord, we are in fact protecting the water body.
Protecting water body, taking the drainage pipeline through his land.
His land, my lord, is claiming that his land. We are claiming that my FTL land, water body, my lord.
FTL Patta, Mr. Harish. FTL government is different, it is FTL Patta land. He has filed thoroughly. What more document you want?
According to section 47 of Application Act, shall not be granted by tax in the set of tax here. But in many cases, they are left with using pattas. It does not mean that because they are having pattas.
You are getting instructions for acquiring this land. That's all. Only on that ground I will adjourn. Status order will be passed. Injustice might have been done to thousands of people. What happened when people wanted to construct as per master plan? Without even understanding the consequences, everyone had to leave setbacks 100, 200, 300 square yards, 5 feet, 10 feet. I will give example of Himat Nagar and Bashir Bagh. Today, if you have to construct a multi-storied building, you are supposed to go by the master plan. Earlier it was 80 feet, today as per master plan of 1980 it was 100 feet. Kukatpalli 150 feet. So when building permission was released, people did not insist for compensation. What happened? That decision was rendered by Justice M.S. Ramchandra. Once you acquire, land is vested in you. For granting building permission, you cannot ask him to surrender. It is violation of Article 300. Same thing applies here. So, did you challenge that judgment? I have given that. You know about that judgment. Even when land is there, I am giving you example. Suppose in Himat Nagar, old building is there. If he applies for building permission, he will be asked to leave setback. Yes. You said if undertaking is given, government has to pay compensation to everyone. All closed cases will be reopened. I am giving you an example, not hundreds, thousands of buildings were constructed, giving land free of cost, thinking that municipal corporation insisted, we have surrendered, they have surrendered. Judgment is otherwise. They said you cannot insist them to surrender.
My contention is that if property is forming part of water body, they cannot take absolutely. If they want to deal with the rights against the government, saying that it is not a water body.
Acquire. I am saying I am not. I will not come in your way. Please acquire it.
Will come into picture, my lord. Their rights are established by saying that this particular property is falling outside the FTL area. That is what my lord, honorable first court said in point number 5.
However, in the opinion of this court, after the
they'll get a compensation because as
you give undertaking and go ahead. That's all.
Well, subject to allowing the repetition, malady is your lordship, sir, I will pass the orders. But
When you will retire, I will retire. You want this order to be passed after your and my retirement?
work was already completed.
If injustice is done, it has to be undone today itself. That's all. I don't believe. Tomorrow, what happens tomorrow, I will sit here, I do not know. Tomorrow, whether I will be here or on the hospital bed, I do not know. I don't know. I have seen many things. If I am in a position to do justice, I do justice today itself. That's all. I don't believe tomorrow. I don't believe anyone. I believe only myself. That's all. Get instructions by 4:30. Otherwise, order will be passed. Whether it is one case or 1,000 cases, 10,000 crores pay. And government can sell lands and make money. Give compensation to the landowners. It is their land. They have to be paid. That's all. Whether it is FTL or ordinary land, they have to be paid compensation. It is their land. His grandfather has given. He is lucky. If your grandfather and my grandfather have not given, let us not have jealousy on it. That's all. Next. He will get compensation, and I am telling you, in Kanamet, let me not disclose that is land
Secondly, their matter for others, and secondly, they take so as on today, they can't develop this land. So my submission.
You also don't develop. They will not develop, you also don't develop.
We are developing, there is interest of mallet. Because the water is mallet, going and inundating nearby colonies mallet.
Yes, for the sake of public purpose, that is what I wanted to do, but since he has pointed out there are pipelines and if you lay pipeline, it is of zero value. You undertaking, you take instructions, they'll give you time.
Now I cannot give a
Which matter?
Lord, what is happening? This is a they claim a lot, government claims this land to be side land. We challenged it, it was allowed my lord, against which the government took it in SLP, no stay has been granted. So my lord, my title is clear. So it is the government whose claim is pending without there being any stay on the order, which says my lord that this is Patana. This is the order passed my lord. So as I today, where we established, so we not give them any permissions, my lord.
Yes. Government will not give them permission, so what?
So, my submission is mallet, working to our mallet subject to second last condition mallet, subject to any condition. Second last page, third paragraph from the top. For the reasons aforementioned, and conclusions reached by us having regard to the fact that the action of the initiative was based on letter addressed to as with regard to the complexity of the issue, or since 1960 onward, land has been changed several times, and the persons who know the issue are not aware of the nature of occupancy. Occupancy rights assigned to be passed the following. Whenever any proceeding initiated by the review authority for result of the land, specify the nature of occupancy rights granted, namely the occupancy granted of collection market value against the land. To a person, whether this land policy is area restricting the area by area as per the notification. Section 58 of Telangana areas. Act number 9 of 1920 applies to the nature of occupancy rights. If any change in the revenue records affecting reasons for the change from personal question. In notice to be issued, enabling them to make an effective explanation to meet the contextual submit their explanation. Unless a particular furnished to submitting the explanation, land cannot be resumed merely based upon the revenue entries. Pass the following order. When next are allowed. Against this, they go on SLP, no stay granted. And in this entire writ petition that is there.
Your land was also included
Yes,
in this?
yes, yes, my lord. Yeah, and my lord, what is the star?
Side land.
Yes. For my side, sir, to take. I'll also take the only put I'll just see another thing. My lord, in this judgment that was passed on by you. It is number 5. Yes, if right is an interest of the petition, are denied by the constitutional response. The difficulties of response is private response or any other person within the interest complexity and intellectuality. It is open to all the petitioner private individuals opposed to the court seeking declaration of their title. If the petitioner private individual succeed in establishing their title about the lands or the FPL, the official respondent subject to their right to appeal shall take steps to pay compensation if all the petitioner private individuals according to the law. Next panel. Under any circumstances, the petitioners or other individuals included shall not obstruct the constitutional respondent from erecting fencing covering the exterior after the exercise of survey is complete and subject to their right to.
Mr. Harish, all these observations only are for protecting water bodies. Water bodies. On water bodies, I will not grant any order today. Managed water, you are changing the nature of land.
And not the FPL limits are already there. It's not on our land. It's away from our land. Not going to be treated as of today. What I'm saying is, this is reverse jurisprudence. They can come to my land. Thereafter, issue a notice and say that
cannot be the point to be decided. What will they do with the land? We do not know. It's their land.
We are saying is that as it is located in the FTA area, section 24 of land and also section 2 of land encroachment act. This land is automatically registered to state. For example, my lord, they are saying that their names are there in the ROR, as per the ROR Act. But according to the not of the kind of as well, the provisions of ROR Act does not apply to the government land. That rule 3 years increase their merit in ROR Act. Here it says so. When the architectural does not apply to government land, the question of merit, their invitation is not coming to my bench. When I clearly say, this case is
Which act does not apply to government?
ROR Act does not apply.
Yes, yeah, but today his name is there in Dharni record.
Very holds in my favor.
It is not a government land.
They're basing on old records. Now what I'm saying is that section 47 Litigation Act also says, granting the pattas, correct? Nothing but what is an issue?
Challenge the pattas, challenge the Dharni entries, who is stopping you?
But was every response judgment, division bench clearly said, even if an order is void, which passed by a district collector, in that case, my lord, where it is given rights, even if it's stated to be void, has to be challenged, otherwise it is in operation. So today here, not only have they not challenged it, there is a division bench that has crystallized rights in my favor. They go on SLP, no stay granted, without notice, they come into my land.
Tomorrow, for any reason, tomorrow, it always said by Supreme Court. SLP is alone.
Then you proceed.
Then my lord, the work will be stopped and everything will.
No,
what I'm saying is, work may go on, my lord, will pay them compensation if really they win the case.
On that premise, if we decline passing interim orders, Mr. Harish, in all cases, public purpose. Colorable excess, in every case, public purpose is involved. What else government is for? Only to do public good. Everywhere public purpose will be there. What else it is?
This is our jurisdiction, our land. They are saying that it is their land. But according to this, I am laying a whole this judgment.
You come up with any undertaking, you discuss.
But undertaking, what I am saying, we'll acquire the land, but they have to. Adjudicate the right to put.
I don't have to adjudicate. I have to. They have, because
Right now,
rights have been
government is right now, there is no state. Government is right now disputing the title. Right? We can't give now any undertaking this matter.
Do you have any rough sketch plan how much land is being acquired?
No, nothing is being, we don't have, there's no actual check of
I'll place all those maps and everything. What is the extent they are looking?
even if that is the case, even if that is the case, where is the notice given to me? If they can they, I ask myself, can they walk into my land without a notice being given, then say, my lord, that this land they will acquire at a later point. With due respect, that cannot be done, my lord. Even a trespasser on a land, my lord, cannot be thrown out.
No, Mr. Tarun, it is for protection of water bodies.
That is where the distinction, my lord. At first, he said, my lord, that land council stated, my lord, it is for protection of water bodies. Now, he, my lord, he says it is for drainage of drainage. Now, my lord, it's admitted that drainage for drainage. All for the last 9 years, my lord, there has been no issue with drainage apparently, my lord. Now they have. And without notice, they want to come into my land. I asked myself this, my lord, this judgment was passed in 2016. In 2014, my neighbor's land, where the status quo is there. From then till now, they cannot come. Let the same
By
status
tomorrow morning, you please inform me how much land is being.
in the meanwhile, status quo may have to be passed, my lord. They are continuing work as on today.
Tomorrow, what is the situation? What difference it makes?
I'll place all the documents before to come by tomorrow, madam. Meanwhile, if any status quo is given, madam, automatically it will continue. That's the only.
My lord, I'll have to only say, if really, today, my lord, on the face of it, notice has not been given, survey has not been conducted. Those are the two, but that. On the, let them file a counter, let have it next week, let the status quo be there.
My reply is, every year is not.
Also, you are saying, I am presuming it is FTL. When did I say it is not FTL? Even if it is FTL, you cannot use for any other purpose except for water bodies. That is my point.
Then, if that is the case, madam, how can they develop this land? Where is the urgency in this matter?
Who is
Only they can cultivate this land. Let them keep that undertaking. Record that undertaking.
You are developing. Who is
I'm not
whose case it is?
What they say, records status that I'm not, that's not, for cultivation of the land, if pipes are going beneath the land, what will happen to them, We are laying the pipelines, almost under the 5 feet or 6 feet. How they are affected, if their case is correct,
Produce the plan tomorrow, how much extent of land? Mr. Varun, tomorrow it will come in page 1. Let me.
They're continuing with the work as we speak, my lord. Let them show notice given to me.
To post tomorrow.
My lord, they're continuing the work without any notice.
Mr. Varun, 1 minute, let me.
I can't wait for them to dig my land and then say, no, you can't. Subject to outcome of the requisition tomorrow, if your lordship has passed, they'll dig the entire thing today, my lord. I'll be put to irreparable without there being a notice given. Sorry, let me finish. Without there being a notice given to me. Where is the notice, my lord? Let them show that a notice has been given, my lord. I will not have a case. No notice has been given. Can any person, I ask myself, walk onto a piece of land, my lord, say this is my land, even if it's a government, even if it's state, even if it's any entity, my lord, notice is mandatory in law. That is the jurisprudence, my lord, of this honorable court. Notice without notice being given, they walk and follow and traffic.
You also file a sketch plan showing how much extent of land is being taken and modify this order.
Already said.
Yes. When do you want? Week 11.
So the order copy, my lord.
Yes.
He also can't do it.
Item 74, 75, 76, 78.
Your Honor, item 49, Your Honor.
on the last occasion I submitted. I will file objections along with the compilation patterns already filed with reference to only this Panchanama. The crux of the matter is whether the Panchanama dated 8/2007. None of the papers are new. They are compilation of the papers already filed in the material paper. Only compiled and I made my submissions earlier. Only I
For GP.
This is for GP. In fact, my learned friend said it is for the government to defend.
Please take time whenever you want. Yes, madam.
Foundation is complicated, fine.
When do you want? Yes, sir.
Item 44, Mrs. Bharadwaj Associates. Item 82, BVS Murthy.
Lordship, Senior Counsel C.U. Mohan Reddy is on line, Lordships.
Yes.
మీరు అన్మ్యూట్ చేయండి సార్, మీరు అన్మ్యూట్. కెమెరా ఆఫీస్ కెమెరా ఎందుకు ఆపారు? కెమెరా ఆన్ చేయండి సార్, కెమెరా ఆన్ చేయండి, కెమెరా ఆన్ చేయండి సార్, కెమెరా ఆన్ చేయండి.
Yeah, relying on honest policy, page 26. What did you want GP to special?
Fathers are wanted there.
This point, this matter was argued by you. You argued this matter. This vendor applied for regularization.
Vendor filed an application under section GMS number 455.
Yes. Please go to page 5 of contract. First page 4, paragraph 4. Fifth line. As per records 1, so as per regularization application in terms of GMS 650. Read by
Page 5 a lot.
page 4, paragraph 4. Fifth line.
As per
Yes. Indorti Satyamurthy has filed regularization. Please go to page 5. Fifth line. During pendency of application, filed for regularization, vendor of the petitioner has sold subject lot. Petitioner herein failed to file any application sold. Petitioner has no right. So that is the only point involved. You argued this matter. So go to page 16 of writ papers.
Yes.
Same person sold land. Satyamurthy.
Yes.
Point involved is whether petitioners belief in the writ petition is to direct respond not to insist for NOC from ULC authorities.
Finally, since it was completed. The short form letter which I mentioned. That's why I did not ask for NOC from US. That is a view of the surface land restricting me.
It seems to be some technical problem.
Lordship, so please just Lordship post the matter tomorrow 2:30 Lordship.
Yes, tomorrow.
2:30 Lordship, so please. Yes.
Continuation matter. Item 41. Dr. Ramchandra Rao. Ramchandra Rao.
You want to argue, madam?
It's not yet filed, it's not, so it's pending partitions in this filing. This succession order has is the question, succession is from the appeal. So the partitions it is pending, it is coming, it's a stage of arguments, check the cover, it is no officer. That's the reason this.
Diva is the father. He died during the pregnancy of the.
Show me the plaint.
It's filed in 2009, so we are only claiming based on 50, which is executed in 2017.
For the restriction, we are denying the shares to the plaintiffs. So that's a matter has to be decided by the civil court. During the pregnancy of the restriction, the Diva died is the father.
You are the plaintiff.
Yes, the sisters of the.
Where is this person shown? Defendant number 3. 2009 suit. Why can't you wait?
Just asking them to wait because we have denied the share to the plaintiffs.
Already.
So the aspect of succession is entirely different from the aspect of the share. Whether the plaintiffs are entitled for the share, it has to be decided by the civil court. So when the matter is seized by the civil court,
How are they benefited with this impugned order?
the civil court may swear away by the.
Yes, madam.
So either they are getting the right agreement, after that nothing being. Father is staying with the daughters. The reputation saying the son is not taking care of the mother. And after that, actually the land is not, the order is in partition by any of them. And the reputation is on the respondents. There's 9 vacant.
Where is order dated 5/2/2020? You claim succession on the basis of will.
No, they are.
Shareholders, we have discussed too much, they are the daughter and.
How, sir? How did you exclude petitioner? How petitioner was excluded?
Because we have filed a succession petition, we have filed a partition.
Where is the succession order?
On
Additional medical care.
Right to which. Petition has the legal explanation.
1 minute. Petitioner is also son of Narasimha Reddy.
Yes. The defendant number 3 to suit.
And who is the respondent? Wife of Yavangi Reddy. Who are they? 5, 6, 7, 8 are daughters of Narasimha Reddy.
Yes, 5, 6, and 7 is daughters. And 8 is another. All of them have been.
5, 6, and 7 are daughters.
5 is wife.
5 is wife.
6 and 7 are filed.
Going by 1 minute. Why son was excluded? I have asked you, madam. Why son was excluded in the succession?
got the share.
Where, go to the additional papers.
The papers are not here. Yes, I will actually.
Where is son's name?
Like each of them are really, given 6 acres each.
Other 2 daughters, 2 sons. They are given.
6 each of the 7 acres and all, they were given only 6.5 acres.
What is your grievance now?
Yes, sister, I am contesting this, they have no share.
Daughters do not have share,
Share.
according to you.
Sorry.
Even now you are arguing that point.
And the matter is whether they are entitled for share is to be decided by the Supreme Court.
Show me the plate.
That says 36 has been represented.
Let us go to the prayer. How much share you asked?
Saving by a will be the share, but it's.
1 minute. 1 minute.
Page number 5.
Nanta Lakshmi. Why they are aggrieved even after succession? Fruit.
This say pending.
Yes, see, in the year 2009, Sultan filed.
According to you, 6 acres each is given.
Yes.
In spite of that, why did the daughters file suit?
Even if the sufficiency petition was filed, suit is filed in 2009, and they are claiming by a will deed of 2017. And the succession deed also will be made to 2021.
Yes, the suit was filed in the year.
What is your claim in father's property?
My father's property, my father himself filed the legal statement stating that they have given the share. Relatives were given the share at the time of marriages, and they are not entitled for any share. Yes.
When did your father is party here?
Yes, he was a leaver because the succession came into force. He died in the year 2009.
Do you have father's written statement? What did he say?
He denied the share.
What is the nature of acquisition? Is it
Acquisition means at the time of marriages, they have given their share, money and everything. This was recorded. So, the civil court decided the matter whether they are entitled for any share. If civil court is a verdict that they are entitled for share, nobody will stop them from taking the property.
today? Why should we disturb this order? As per judgment of Supreme Court, daughters are entitled whether 1985.
Exactly, I'm just putting it. Let the court, civil court decide. If the civil court decide that plaintiffs, if other daughters are contested.
What is the benefit to you if I set aside this order? 1 minute. What is the benefit?
The civil court comes to a declare.
I asked you,
Yes, yes.
they might be getting Raitu Bandhu. What is the benefit to you if I set aside this order? Please tell me.
The civil court will not be paid by the order of this.
Why will civil court be influenced?
Just because they are claiming that they are under the succession guard, they got the share. That is exactly their argument. Before the civil court. Let the civil court decide. Because
I will clarify, civil court shall not be influenced by order passed by the MRO granting succession.
Their estimate is also 7 acres each they should have got, but only 6 acres are not being granted. Daughters and the mother. Additional 5 acres also he has been. So he has managed to get a pass.
as rightly asked by this court, that what benefit I am getting. Suppose if the suit is now, the will was executed during the pendency of the suit. The father thus given executed a will deed in my favor during the pendency of the suit. Now that will is also in has to be decided, the validity of the will has to be decided.
1 minute. Who applied for succession, madam?
They applied for succession without issuing any notice.
You applied for succession pending suit.
Yes.
Then it has to be set aside.
Even if it is statistic launch, the entries will be put back without the impact is the part of the plaintiffs. So that is going to be a whole use by the parties. So it is related to only the thing is that they are enjoying the rights, but the mother also is with the daughters.
Now plaintiffs applied for succession.
Yes,
Plaintiffs.
yes, everybody has got that shares. In fact, the
After, so during pendency of the suit, father died. And instead of pursuing the suit, you went to MRO and applied for succession.
Without registering any notice to the.
that was termination, that was third and last.
Page 160 paper. Yes.
What is the prejudice if this order is set aside?
Is that they will be getting the strike, and though that which is not, the mother is with the daughters, that is one of the issue. And moreover, the judge is not, the no judge, there is no officer who is the. It is a fact and you're not because it's the state of arguments. It's remained.
This honorable could directly,
There is no
in charge judges there, is not taking up the case.
No, I cannot direct, but you please tell me who is cultivating today?
Yes, sir.
Please come.
Yeah.
This is got instructions to take.
Shishara and others are cultivating.
Yes.
Yeah, they belong to the. They are not
Question stays in the same position. Because typically asks this question as soon as it was cultivating, nobody is cultivating. It's like we.
Using the lifetime of your father, you are cultivating, the father is cultivating the life. So this, because the petitioners are residing in some other village, they are not supposed, they are doing their own cultivation.
See, if I set aside this other order, neither you are benefited, they are benefited.
Because first of all, no.
So even if you are not benefited, they should not be benefited.
It is not my case.
That is the Indian
Because
mentality.
because it should not be produced by whatever the order.
I have asked you about Raitu Bandhu. Let us not touch any possession aspect. Since they are receiving, according to learned counsel, if I modify this order, they will be deprived of Raitu Bandhu benefits. What is your answer?
First of all, before passing an order as per 5(3) of the Labour Act, notice has to be given. I have given page 36, I have given prior intimation to the Tahsildar that since the petition suit is pending before the Supreme Court, no succession should be granted. In spite of that, my prior notice also, letter also, the Tahsildar did not give any notice to me for deciding the case. So as on the face of it, it is the order of the Tahsildar granting succession. How can he grant a succession without the presence of the other connected concerned parties?
You please tell me, neither you are benefited, they are benefited. Who will take Raitu Bandhu?
This is not a question. Once they get, because the
Raitu Bandhu is the only question now. Everyone wants that.
let this would be decided, sir.
Madam, technical problem you have. What is to be done now? Unfortunately, he will lose, you will also lose.
Yeah, it is a fact and at the stage of arguments.
Raitu Bandhu does not come in the way of deciding this as per law. So they will not be.
Even if I am disposing of the main suit, this is like an interim order pending partition suit. So this is an interim arrangement. I have to balance the situation. When you don't get anything, still you do not want your mother and sisters to get anything.
It's not the case. Not the case. Because when
What else it is?
when I have.
If you are benefited in any way, I can understand. You are not benefited in any way.
Because I have not been given any passport or receiving any tax funds. So they have taken. Right month is started and it's to decide whether legality of this order. Because the order of the Tahsildar itself on the face of it without issuing any notice, in spite of my prior intimation in various.
Since when Madam succession is 2020, much later, 11 years after father died.
This bed has let this succession order not be reflected in the past. That order, that arrangement can be made, it's goes for the see.
Because it's a law. Arrangement is this, not the law.
Yes, what he said is correct. We have to, though both will be put to loss. He is saying we have to go by law, so I will also go by law. Yes, third learned counsel for the petitioner. What can I do? You enter into compromise for Raitu Bandhu, yes. Brother and sister,
We are ready for compromise.
ready means what?
That's exactly why this suit is being pending.
Tell me, you want me to dictate the order or you will have some arrangement for Rajapanda benefits? Madam, pending partition suit you applied. What can I do? In what way I can pass order in your favor? Tell me. And father filed written statement against you. So I will go by. You today we are concerned with succession pending partition suit. You did not have any share when father was alive. You filed partition suit. 2009 suit filed. During pendency of suit, father filed. You went for succession, which should not have been entertained. How can you go pending partition suit?
What happens? Now, during the pendency of father died, prior to his death, he had instituted a will for his property of the petition. Now, suppose if this order is not sent as right, now the written statement of the father is there on the record. Now, if that court comes to a conclusion that the plaintiffs have no right, no share in the property, then this proceedings will be there. It may come in the way of.
How it will come? How it will come? Read section
That is
7.
exactly my concern that the trial court.
How will it come in your way? Read section 7 that proceeding will become non-ester. Proceeding will become void.
Let us go
As per law. That is the only argument he says. Yes, heard learned counsel for the. This order is not sustainable.
Officer and
Mr. Rahul Bhaskar. Item 49, Mr. Matin Qureshi.
I will present on behalf of Matin Qureshi, Your Honor.
Pass orders.
Much obliged.
Item 50, Mr. Nagendra.
Brother, they are having some part of
Respondent.
Page number 15.
Page number?
15.
Why are they aggrieved?
No, no. No, they have only issued the notice to the concerned parties. They have not conducted any function or survey in the presence of the petitioner. Now, after the filing of the petition, in the earlier occasion also, they stated that it is not conducted pursuant to that. And now they suddenly say that they are having the report. My only submission is that, I have made a application, which is that Lord's mechanism.
Challenge it. File a civil suit.
My own page number 46 is anything. Pursuant to this, first one is page number 44.
How are you aggrieved by this joint survey?
44. Page number 44. They themselves say that petitioners are having the right to. Personal candidacy, the third pair. It's not clear whether the applicant's land is coming inside the non-guarding elected or copy of joint survey.
Page 40.
44.
44.
Yes, yes.
Letter dated 3/5/2019.
They have addressed letter and they sought the survey.
Which para?
Last paragraph, in view of the above, it is requested to kindly arrange, conduct joint survey and fix up boundaries of survey number 822, 670 and 670. Petitioner's land is under the survey number 670 and 671. And the 82 belongs to forest land. Which is adjacent. Petitioners are having another problem. They are receiving right from those, they are in possession. They are not able to enjoy the possession peacefully. That is the reason why they have.
If in the survey it was found that land claimed by you is a forest land, what can I do here?
They have not conducted page 50. My humble submission is that let the survey conducted not in the presence by issuing proper notices to the parties.
Where is the survey report?
That is, it was not served on us.
Page 50.
Please show kindly see why they have issued again a notice. Notice is also at page number. Page number 45 is kindly page number 45. Pursuant to this, they have not conducted any survey. Page number 45 very clearly says that they have called for the appearance of the parties. What happened next is not known. I am only asking the Lord, let them conduct a joint survey.
What do you say? Page 45.
In a time bound manner, let them conduct a survey and petitioner will cooperate.
And page number 51.
This is 2012. We are concerned with 2019 survey notice.
Not find out. Should not find out that subject.
So you find out what is the status of this proceeding dated 27/8/20 in this file number 527 of 2019. When will you file?
In order possible to this, they have to conduct a survey. They can conduct survey within the time bound manner.
GP Forest seeks file contract. There should be.
Voting of reservation before they are able to.
GP mandate.
But they request to note earlier, the CRP was filed in order.
You can speak to the GP land reforms. Yes, what is your stand now?
As per in the order flow, it stated to remand back in connect right time. But not on the same appeal number, Malad, CC2 for a deputy 75. One of the parties approached Malad, that was Malad CR2 was filed. This is Malad. From orders that passed in this thing under from review petition has been filed, Malad. I have 1, 2, 3 and 4. And CRP 167 of 22. Same space. Last paragraph, Malad, they said.
Very difficult to understand that instructions you have got.
At least he has used word sub judice. Because it is sub judice, you dismiss this writ petition with that. One line is enough to understand. We'll give them time.
Let me explain that in respect of water industry. Mustafa Corporation has quite a challenging process. Declaration for the other. That was challenged by one third party paying the time the owner of the property. That petition was allowed for reopen. The honorable then said that you give the notice to all the interested parties. After coming to I also participated. Like that, 3-4 members have participated. In the same way, one of the party which has filed an application for reopening of the case, that she has a claim over the state property and it can't be declared as a excess land. That was dismissed. Against this, they went to the district court. That was also dismissed. Against which CRP has been paid. Now the CRP is paid. So in respect of my claim, Your Lordship, my petition was dismissed. The petition was rejected, Your Lordship, at page number. The same way, in the same manner, I also one of the party went there, page number 51.
Independently decide his case. Why are you waiting for another CRP which is pending?
And it was allowed, Your Lordship, page number 53. My application was.
Unless and until his claim is clashing with the claim of this petitioner.
If there is an order in my favor, kindly see the page number 2.
Ask, discuss with the RDO. Friday. Or you want 1 week next week? Yes.
Item 52, Mr. Vijay Anmol Singh.
Purchase of the land and the public auction conducted by a cooperative bank. Purchase or sale of the land by the cooperative.
Have you filed Dharni application?
We have filed the. have filed the- And it is at page 12,
Dharni.
We filed only to give us particular passbook.
If I revenue reports in respect of land revenue. Submit application, I'll pass out. Now since digitization is in vogue.
80% of the Indians are illiterate. Now, if the courts ask them to go before online and make a submission,
80% are illiterate. That's why literate lawyers like you have to guide them.
that is what the application given. Look, the Dharani doesn't say that.
Entire world thought Indians are illiterate. They cannot manage digital money. Now you know why our economy has reached trillions. Why? Because even a street vendor does business on Google Pay. Everything is deposited in bank. That's why India has become a
Change law to give small change to purchase the seller. The reason he is giving the.
That's why I am not used digital currency. You start using, I'll also start using Paytm or Google Pay. Everyone knows it's not a, when it is necessary, everyone will adapt to it. Please apply. Apply within 1 week, I'll pass. Yes, if they refuse, please come back.
Item 54, Mr. M. Damodar.
Motion is please. He wants time. How much time? Yes, one.
Item 55. Item 55, Mr. Kiran Palakurti.
You have an interim order.
Another survey in the last time.
Item 56, Arnav.
I beg to represent Mr. Harnath, my lord, in this matter. Counter has not yet been filed by the respondents, my lord. ORC to the respondent number 6 has been challenged herewith, in spite of notice being asked to be sent to the petitioner herein. No notice was sent before granting of the ORC to the respondent number 6.
One number 16.
Best of luck.
Item 57.
Much obliged.
Hanumantrao.
Challenging. Survey conducted by the post respondent. The instance of responding artificial respondent purpose center.
Have entry model.
Yes. No commenter has been filed even today.
The survey conducted by HIGHCOURT.
Counter.
Surveys conducted by the district surveyor, madam, we have no objection. Now, this one of the restriction is
Suit is pending in the initial order in my favor, which is a page number 32.
Counter not filed. 2811.
Item 58, Mr. K. Durga Prasad.
The rejection of application under 59 Joe. So,
Why?
no reason. I mean, wrong time. They are not filing. Only online they inform you that. Not getting the confirm.
Keeping assignment.
Item 59.
Industrial area is not high. This is the difference.
Example 2000 square yards. There is no limit.
No limit.
2000 square yards.
Even acres also there.
That is the best way now to become rich then.
Yes.
Occupy and file regularization.
There are so many.
One should, so according to you, no one should work hard.
No,
Easy to occupy and
Regulate.
apply. That is the advice you give to the client.
No, we received from the authorities and we got the orders also.
I can understand a landless for 2000 square yards, how it can be regularized.
They recognize the acres also.
Item 59, Mr. Srinivas Rao.
Page number 21 of the page 25.
Page
21.
Rashford used to pass an order.
Page 24, you know.
Why so many writs have been filed by you?
No. This is filed by other person. Respondent. We have the opposite discussion, we must be page 24, paragraph 4. So the director and second point to consider the opposite online application submit the petition part of a purpose in accordance with law by putting a petition all affected person only and according them an opportunity of hearing. Then we ask me when you go to page 27. Petition order.
And the respondent of full. I'll get state petition.
You must kind of page 27. Part of accordingly. My case is that one the Pune Venkaya is claiming the property. Notice was not even given to Naya and the order has been issue has been decided. The also please to grant status for others.
What do you say? The inquiry report of Tehsildar says you are not in possession of the property.
No way concern the order from the property, I am question of the property. I have filed the document.
Page number please, class, can see party.
Page.
Party.
But my document.
Our claim was also rejected on 2022 last. I request to last, please can you permit me read that? There are 4 letters. Page number 40. Yes. This means who the patient has approached the Honorable High Court and filed petition number 74. They plead to insert our name and to see the land sir number 74. In this matter, the district collector has heard on the case and issued the memo in 18/8/2022 that her plea cannot be considered and there are no valid documents supporting her claim.
Which are all without verifying any document, they say that I have filed my all the documents and additional document not all the documents show that not my vendors has got particular process, I have on the same day. I will hear tomorrow, next week.
Item 16, Mr. Gudima Sudhan Reddy. Item 16, 61, 62, 63.
What happened now? These people, they issued a notice every month they want. When do you want? What happened? Last occasion, Milord, Narendra Prasad appeared. He wants time. In the meantime, Milord, they are insisting for 5 lakhs rupees towards rent. Now, Milord, they are insisting threatening to evict. Your Lordship, last occasion heard. Your Lordship,
10 never at the request of learned special chief.
The last occasion also.
They didn't come on
But they are insisting to pay 5 lakhs every month. They have regularized some of the industries at 1,000 rupees per square yard.
We will hear on the list.
Item 64.
Fourth time Milord is coming.
Yes, Mr. Ramna.
Yes, Milord. May I please the Lord, Milord? Milord, 5 guntas of private patta land of the petitioner was Milord high-handedly Milord MRO conducted a Panchanama and handed over it to 6th respondent Grama Panchayat for conducting a Grama Panchayat building. At that time, I filed this writ petition. This court granted Milord status quo after satisfying with Pattadar passbooks and everything, and Nala proceedings subsequently granted by the competent authority. Now, Milord, after granting interim order, I made a representation for conducting a survey afresh. Now, the MRO conducted a survey and stated, Milord, by mistake, they have handed a earlier conducted Panchanama, treating it as a part of government land. But in fact, this is a part of private land, belongs to me. I filed that report at page 22. Last para is the report submitted by the Milord, Assistant Director for Survey and Settlements to the MRO. Page 22. This is recent survey after filing writ petition.
Additional documents.
Pardon, Milord.
You can file additional documents.
IA2, Milord. IA2, I enclosed the report at page 21. 22 is the operative portion. Page 22, last but one para, Your Lordship, so pleases. Further, the land allotted for construction of Grama Panchayat building in survey number 190 is not government land. The Tahsil office has handed over the land through Panchanama. The said land is 190 by 47, 190 by 129. This is my land, Milord. Patta land. The same was prepared locations. Kanakamadala Koteswar Rao is the petitioner, Milord. Has submitted Dharani passbook shown as a Pattadar enjoyer of 190 by 129 to an extent of 2 acres 4 guntas. Milord, it is a private patta land, part of private patta land, treating it as a government land. Erroneously, they handed over these 5 guntas to Grama Panchayat for construction.
1 minute.
No,
with the survey report, it has to be allowed.
Now, Milord, even to raise fencing, Milord, I am not in a position to protect my property.
through the papers.
This one I think 22 million, but lastly this stated of million. Therefore, I am submitting everything above and deputy inspector of service. Report will be more than further action. What was the further action?
The matter is there in the court.
6923. Report is of 6923. What was the further action?
They have treated my patta land as a government and erroneous behind my back conducting a panchanama they have handed over. Now they themselves says it is a part of private patta land. But they don't file any counter because they committed a mistake at the time of handing over. Though these reports are available with MRO, they are not in a position to come before these courts. On the ground, my lord, this court found fault with them.
The learned
IA 2 may be ordered, my lord, because there is an order of status quo. I am not in a position to, my lord, raise a fencing for this, my lord. That is, I am not in a position to protect my property.
I will pass orders, final orders on that day because according to me, it has to be allowed. We go by this circle.
Some specific date you'll also so please, some date.
21/11.
Also please.
Item 65, Mr. M. Ratan Singh.
My lordship, I am appearing in this case for respondent number 3, my lordship.
My humble request, my lord, I am representing on behalf of Ratan, my lord, request day after tomorrow, my lord. Is in
My lordship, I am leaving for
another
Delhi.
court, my lord.
The Senior Citizen Act matter, my lordship, will be taken up. On the last occasion, my lordship has passed on interim orders in this case, my lordship. And the petitioners in the case have given one undertaking before this court that they will be withdrawing all the cases related to DPC and other things. And my lordship has also recorded the statement in the order itself. Now they are putting back and they are telling that we will not consider all these things and they have to render the old conditions. They are putting their own conditions to their father, my lordship, with the respondent number 3, he is a senior citizen.
Same case where son came here and said.
Yes, my lordship.
Grandson's exams were.
Yes, that is on record, my lordship. This was recorded in the order of my lordship, my lordship.
Your client said he will vacate it. You are for parents.
Yes, for the parents, my lordship.
Mr. Ratan, give that order. Has he not vacated?
No, my lordship. My lordship has given a date of 30th/11.
My request, my lord, day after tomorrow, my lord, counsel in another court, my request, my lord.
Lordship, as per the directions of this honorable court, I have recorded one statement of a settlement and I have given to them. But they are not coming forward for the settlement.
Yes, sir.
My lordship, it was taken on 11th, on 10th April.
10th only.
Yes.
Item 66, Shaka Madhu.
Page 12 is disposed.
Item 67, P. Balamohan Reddy.
Is covered by your ordinance order and this is the page number 36. But the unofficial respondent files counter has failed. Since after the order of this honorable court in PIS, the publication was issued, I have not taken step. My case is that no notice of this proceedings was given to me at any point of time. In fact, I have subsequently approached this court in 2023 and this court passed orders to her. While that proceedings are going on, this order came into light. In fact,
what about service of notice to RH?
Yes, but they appeared, they filed counter also.
So you are for 7?
7 only.
Where is 8?
Lord, in fact, they are not even before the authority. In fact, the person.
Made them party.
I made them party, my lord, because the respondent in before special tribunal died at that point of time. On the day of the order, he is no more. In fact, in the writ petition, I made them party because they are claiming the land. Lord, this order has to be set aside. Subsequent to orders of this honorable court in the writ petition, when I approached this court and said, Lord, my revision is pending, I have given no information. This court directed to dispose of that matter. While those proceedings are going on, this order came into light. Lord, those proceedings are initiated and a notice was also issued, which is at page number 32. Because there was no information with regard to earlier proceedings. I approached this court by way of WP 12334.
Yes, you are.
I'm responding by 7 only.
R8 died.
No, R6 died. R6 was responded before special tribunal. By the date of order, he died.
Service of notice. 8.
In fact, the filer both service also.
Even for R8?
Yes, sir. Both service was filed on 8/9/2020.
You want to argue?
Yes, sir.
What is the matter?
My point is, my lord, as per the bill, the government is directed to publish the notice. Call for assistance, but already the matters which were disposed of prior to the passing of the order by the honorable division bench. Accordingly, the district collector Nalgonda called for elections by publishing the notice in all the newspapers. And despite that, the petitioner herein did not raise any objection.
Personal notice was not given.
Personal notices were not ordered.
Paper notice was given.
Even the honorable division bench ordered for only public notices while publicity, not public notice.
Yes.
So, after a long lapse of time, he is fighting another litigation against the same disease responding by 6. While OS number 329, which was dismissed in the year 2023, and he preferred an appeal. And after that, he filed under petition, under the cover that he has no knowledge to show and taken a direction from this honorable court, and then he filed this petition. So he was to cover up his lapses. He filed that petition that he has no knowledge. So therefore, after a long lapse of time, he filed this petition.
2023.
Yes, my lord.
Revenue entries changed.
Revenue entries changed long back. His revision itself in the year 2017, my lord.
You filed counter.
Yes, I filed counter long back.
This order will not come in your way then.
Which order?
This status quo order.
But in fact, the order was in their status quo with regard to exchange without their attention.
Yes.
But I understand who responds. Page number 59 is the order, Lord, and revision is pending before joint collector. Approach this court, Lord. This is before the special tribunal came into place. Page number 59, Lord, that is 7 months, 7 of 2019. Lord, in this, Lord, this honorable court was pleased to grant 6 weeks time for disposal. Thereafter, Lord, no information was given. Then, Lord, approach this court.
I will take up this matter because it was after 2 weeks.
Lord, the only issue to be argued, Lord, whether that order, Lord, pursuant to orders of this court, the file was revoked.
It requires hearing, I will take up. 21.
The motion is, Lord, this short point, it will not take much time out.
G. Ramchandra Rao.
Even I thought the GPS provided written instructions for your lordship. And in that, they are really informed.
They
that-
want some more time.
No, I want some issue. They have really informed that written instructions. As the petitioner did not respond to the notice issued by the respondent number 2, the picture says by the petitioner sir removed. As far as the reply to the notice is concerned, my lord, sir. Page number 29, my lord, the lordship may take a look at page number 29. Should have replied to the notice issued by them on 2022. In the written instructions, the income is not about for that. Since I did not cause any reply, they removed my temporary stretches. They're not even allowing me to calculate my calculate something that.
Not satisfied with this, it's like the department was not satisfied with the.
They have the parental hearing, my lords. Without passing any order, they cannot act upon their own.
Did you get information as to how much area is covered by FTL?
But the lordship has asked me to take the instructions of this point on our last edition. But for some more reason, your lordship has been contacted.
In the month of July, my lord, we have Telescope may be granted for us because they are trying to demolish these strengths.
Item 69, Mr. S. Venkateshwar Reddy.
This your lordship has asked the instructions of the last edition of the law which is decided. Because the clearance has not been made by the government. Because I'll seek further 4 weeks time to establish.
4 weeks. The request of learned AGP 2811.
Lordship may kindly say after listening.
512.
Item 70, Mr. D. Vijay Kumar.
Order. Now they say, by ignoring the charter, they say that because of the matter was referred to the higher committee, they are not in a position to grant the permission adversely. In fact, my Lordship kindly confirms that being the case, when the petrol pumps which are already functioning, even that has to be also closed. The Lordship kindly see the order of Lordship order at page 9 and the direction matter as page 10 matter. The general counsel for the petition submits that in the similar circumstances for that the interim was later so also. In view of the above, there shall be an interim direction to the respondent and pursuer to process an application of the petition dated 5/10/2022 and 10/11/2022 respectively for issuance of obligation certificate in respect of
Why have we not considered the other?
one more aspect, my lord, one more aspect. My lord, then impulse.
That order was implemented?
No, my lord, kindly see page 25. My lord, the order there was kindly see page 25. They issued a proceedings dated 10/2/2023. The relevant at page 27, my lord. In view of the above, once again it is informed that based on the report of the additional collector Rangareddy district as pending restricted so and so power company considered so and so to put up the new retail outlet so and so original building vendor cannot be issued at this juncture. Malad, this Malad, your lordship is direct, Malad, they have not given discretion to them to things. Malad, they have passed this order, Malad, they cannot be granted. But one of the reasons for this rejecting, they have referred my lordship, can you see page 29? That is the office letter of dated 14/6/2022. Page 25. They given one reference. That is reference number 4. That the office
Show me this letter.
That letter is
Commissioner of Police dated 6/6/2020.
from this reference, page 25. Page 25, unnumbered by the last.
That is NOC.
Accordingly, the petitioner was informed, page 25, I am reading last paragraph. Accordingly, the petitioner was informed by this office letter, reference 4th cited, the reference 4th cited is
This office letter dated 14/6/2022. To grant the NOC to put up this so-and-so retail outlet, Village, Kandipet Mandal, Rangareddy district is being kept on board temporarily and when a reply is received from the collector and district minister Rangareddy district, appropriate decision will be taken. In fact, this refer was categorically made in affidavit at page number 60, para 7. While passing this order, this letter also is part of the record before the Grand Court. Even that regarding the letter also is made in my affidavit, para number page 16, para 7. Lakshmi, can you see page 16, para 7? My affidavit, which is filed in the writ petition. It is submitted that even after the Honorable Court have passed the direction to dispose of the application, the petitioners have made to run the so and so. Then the respondents have issued a letter dated 14/6/2022 where R so and so. And after this matter, I have seen this letter, the Supreme Court has directed them to process my application within a period of 4 weeks. Now, again the quoting the very same letter, they say that this was referred to the HIGHCOURT committee and still that HIGHCOURT committee is not pending and this cannot be done. In fact, under the rules, they don't have any other things. They have to be processed within the 45 days. That is page 31. That is page 37. The rules are filed, and the relevant is.
The pursuant orders of the stand of the court dated 10/30/2022. The past orders in 10/2/2023.
That is page 25.
After removing of the restrictions in Geo the HIGHCOURT committee was constituted as Geo 69, wherein the terms of reference was given to the committee to frame out the rules and guidelines. In view of that matter, unless
pending that I asked, that matter was argued on the day.
that 6/6/2022 orders, it is nothing but a letter by the commissioner to the collector for recommendation of the petrol. Can you give an order? That is the letter.
I have also referred to other notices.
Yes, madam. They are all given prior to the constitution of HIGHCOURT. That is in year 2020.
What difference it makes, you know, for what HIGHCOURT committee is constituted for what? To recommend relaxation of GO 111.
Yes, madam, but they are
for amendment of master plan.
Terms of reference was very large. Can you see GO 69? I read along with my counsel.
You?
Last term.
No, I know about this.
Madam, can you see there are five?
Let us assume.
But this they have not
Worst to worst, even if this is included as catchment area. How many petrol bunks are running in this area?
I myself filed 4 applications, 4 permissions in this.
They are all given prior to the constitution of this company. There are 19 applications.
I am saying
There are 19 applications.
because they were given prior to constitution of this committee, committee's report will not be worse than what was there. They will remove it from GO 111 restrictions. Assuming they will not remove it, they will treat it as a catchment area. When 4 or 5 petrol bunks are running in catchment area, how can you reject permission? And moreover, I have also given example. Petrol bunk being constructed, it cannot be treated as a permanent establishment. It is a temporary structure. What are the permanent structures?
There 3 bunks are functioning. The department.
They are all given after there are 19 applications pending before the document. Because in view of the collector's orders, that in view of the additional collector orders, that in view of the HIGHCOURT company constituted, we are waiting for the guidelines. We have not rejected his application. We say we have kept in away.
See guidelines. When will the guidelines come into operation? When
the committee is constituted, the term you are not suited, we can see the. They have
please,
terms of reference.
only advice you have to give is to direct him consider NOC on par with others because the petitioner will be in advantageous position in future. He will not be in more disadvantageous position as he is there today. That he has to understand, the commissioner. Everyone is taking shelter of these technical points. Today it is 0111. Assuming it will continue 0, it cannot be worse than 0111.
But they want to frame such a guidelines. Also, there are 5 minutes for a movement.
Comment officials, I don't know.
Because they want to give some guidelines to suggest measures for protection and prevention of pollution with these 2 reservoirs. These are the terms of reference. To suggest broad guidelines for zoning, including air quality of pollution. To suggest modalities for development of trunk infrastructure in this. To suggest various means of resource mobilization for taking up trunk infrastructure, roads, major drains, STPs, diversion drains. To suggest appropriate institutional.
Challenge this and ask for interim direction.
My only submission, since we have passed an order, persuaded orders.
Order, see,
Register is.
just because you contempt is filed, can you say order is passed?
Orders of this matter, these are done.
Where is the order? Where is the application of mine? You did not do anything. You only discussed about the orders, GO, so and so, High Court committee rejected. That's all. You did not say anything.
We are waiting for the guidelines. We have not rejected, we kept against. We are waiting for the guidelines.
How long?
He's agreed manner, he has to challenge this other.
Just one.
He cannot maintain an attempt.
When any power has given to them to consider whether it has to accept or has to reject, then if they reject it, that is the other thing. But the direction is given to them to positive direction. There is no other opportunity as left to the authorities except they follow the direction of Chamber Court. Now, when this juncture, even I can challenge this. But on the face of the record, this order reflects that violation of the Chamber Court orders.
Who is the officer? You please discuss with him.
Commissioner, this amount to this is a clear content when at the path on the face of the record it is disclosing when the court has the Chamber Court has given a direction to them to process and a positive way.
Friday. I'll pass on.
Say, you know that things are engaged in elections for
My money will taken. They will convert my land from agriculture to non-agriculture. Everything they enjoy. When my thumbs from 2.5 years.
Because of election.
Yes, I am not saying that.
Police will be busy.
Yes, I am not asking for anything. They consider my land. They
Fight well.
Page number 5, item 71, Mr. M. Srinivas.
You please.
Item 72, 73. You are marching.
You want to file counter?
The counter has been filed, my lordship.
Which one this? Nagari district?
Yes.
My lordship, in this case, we are seeking.
Matter they get into. They raised a question in the first petition as to how is government protecting the surplus land. The five dated from this, every staff under the RI, they go and make his rounds every day. That is one part of the prayer to be.
I'll hear.
My lordship, on 10th it may be taken, my lordship, because
Yes.
my lordship, the true picture is this.
I am taking up on 10. Next.
Item 79, T. Purnachandra Rao. Item 80, 81, Sri Prasad.
In this matter, investigation is IFC is allowed. It is not okay. It's reflected in the. This IAF we allowed for your worship in the last.
But that was looking at without the gazette notification.
Whatever
It is a public document. It can come to your lordship. Plus while arguing. We have a possible. That's the only question which went for the lordship.
I am the petitioner, I have to argue the case. What is the urgency in the matter?
Malak, I have urgency.
Yes,
because
tell me what is the urgency?
1 minute. Why is he?
Because I am the petitioner. He is saying one way, it is the first person. He is saying another way, very urgency. What is the urgency? Really, he is having any urgency?
Let him argue, I'll sit down.
Today I am not arguing.
Malak, that's not it. Malak, this matter has come up several times.
Sir, may you wait? 1 minute count.
Since we object to.
1 minute. Wait.
This is not the way.
What is the? Wait.
Eight times 93. Here, some other.
No, please listen.
I don't know.
All I'm trying to say.
Sir, Mayur.
One small submission.
After 4:30, I cannot insist any counsels to have.
Please
That's
notice
it.
your lordship's docket. Any number of times, why I'm expressing my hands, not of mine, but of the client, is that, of the instructing counsel is that, any number of times the matter comes up, the learned counsel doesn't appear, somebody comes on his behalf, takes time. Please notice your lordship's docket. And one more thing, the issue is only one. Passbooks have been given. They get an interim order 2 years ago not to disturb their possession. They have not a shard of paper with them showing ownership of the land.
If I am
Yeah,
right.
1 minute. If he's arguing, let him argue otherwise. What I'm therefore submitting is.
1 minute.
Lordship.
1 minute, Mr. Mayur.
Sir, one more sentence. That your lordship said, when there are passbooks of the respondents of any party member, division bench, my lords have said and said, passbook shall not be cancelled. Only question was whether that land fell within agency area or not. That was the only question. Now, in the IA which has been filed by him before your lordship, Ashwarapet village is not within the agency area. It is not. It is the past, the document says so, gazette notification says, lordship may see, all the villages of Palavancha Taluk of Warangal district, excluding Palavancha, Golgampad, Ashwarapet, Damapet, Kapur and Nalipa. So Ashwarapet village is the village in which we have Patadar passbooks. Therefore, my lords, if it is not an agency area, they say our land is in the agency area, but we fraudulently, with the connivance of the Tehsil of the collectorate, bought Patadar passbooks for Ashwarapet village because it's excluded. My respectful submission is that's a question of fact. We go before the collectorate, let them produce evidence before the collectorate. Our argument was we are in Ashwarapet village.
What is your case?
The land is situated in the Wakachagura village, not the sort of fact. If it is a plain area, nobody is stopped them to register the document. Let them show the register saying, I am out of the court.
Passbooks are all there, will show that Ashwarapet village, 1 minute. Ashwarapet village. Not even have it tomorrow, Malak, because and
Next week, I'll hear.
Anytime this week, Malak.
Yes, what do you say? Tell.
Anytime this week.
Last week, the Diwali festival, your last No.4 treasure of the advocates. Why should I be wasting their time? What are these urgency?
I am saying, what is their urgency? Their urgency.
I have urgency on the land.
You are in position.
2 years, Malak, since 2 years.
You are in position and there is some.
by virtue of the order, and if we are in the invoice, what is the, by virtue of the.
Which day do you want, Mr. Srinivas?
Anytime also be one. No, not this way. This matter has been pending.
He wants to celebrate Diwali and come.
That is in the weekend and the extended weekend. Let it celebrate after the.
After Diwali, he should celebrate.
My mother can show the register sending. Who is ready to stand before you?
14.
Is this a PIL?
14. Mr. See, after 4:30, I have made it very clear if opposite councils are not interested, I am not insisting.
This is
Let
not
us.
the first time.
No, I understand, but
Small submission I may make. This is been treated in a very casual way. The manner in which arguments are being proceeded, madam. Let it be at 2:30, madam.
no, on that day, please make a request, not now. Because I have got one or two international arbitration matters. They are taking long time.
Yesterday also that.
Yes, please mention on that particular
Anytime
day.
this week, Friday or.
Let it come next week. This week I am.
Madam, finally, my lord's blessing.
On that day, let it come. 83.
Item 83.
I decide on it. IA2 is for?
To receiving the external document.
Yes, application in IA2 allowed.
Receiving of the cousin.
IA2 allowed unopposed.
Next, my lord's blessing.
Let it come, Mr. You. Next 83.
83, Mr.
The
Srikanth.
vacancy is pending for 2 years. I myself has appeared before your lord.
I'll see.
Srikanth. Not it.
I'm obliged.
Yes, next.
Item 84. The BKA construction 14%.
The authority, registering authority has to cancel. Yes. Which one?
Was removed from the approved inspection area to grants removal from approved list under stated 11/9/2023. But this is not because they always mention that color this is challenge. And secondly, coming to last paragraph, what we are saying is
That is challenged in this code. Yes.
this matter, this is challenge. 16/10/2023 is challenge.
Yes.
16/10/2023 passed by as irrigation department. When they applied for renewal of their license merit, what they have stated was, your name was already removed by proceeding dated 11/9/2023 by the Panchayat Raj department. So this order is still in force. And this order is still in force, Malad, we can't renew our application on that ground.
Where is that order then?
Actually, they supposed to file.
It's not communicated to the government.
This,
This is the compliance which I have given you.
That is by competent authority.
Yes, competent authority. Yes. According to rules, Malad, whoever has removed that name, Malad, they have only,
Whoever has registered
sorry,
can remove.
can remove and thereafter, Malad, restoration of that name also, Malad, they have to do. So here, Panchayat Raj department is Malad,
11/9/2023.
yes, Malad, 11/9/2023.
Page number,
The
madam.
name was removed on the ground that Malad, they failed to execute works on several occasions. On that 11/9/2023, Malad, that the plea was taken.
Who is the competent authority?
Committee of Chief Engineer.
And committee of C pages are confident to renewal and registration.
Page 128 and 129. On 129, fourth last clause. Registering authority may remove the name of contractor from approved list if the contractor fails to execute.
Have you not received this, these papers?
this 11-9 order is not communicated to us. Only this respondent number 4 has informed us.
First you take 11-9-2023 proceedings and you please answer.
11-9.
11-9 proceedings, you take it from GP.
11-9 proceedings, they are not communicated to us, but whatever he.
Why don't you take it now? You are having it.
But it complaints are already communicated in this.
We are not concerned with the country. We are concerned with the competency of the person who has removed you from the list. No, let him go through it.
Yes, yes. That was passed by Manchara department, not by Judicial department. I can see page number 5 minutes. The staff person paragraph. We have wrote this application.
Madam, give one more set to me.
Your Lordship, I can understand what it could be there in it because they have clearly mentioned this. I am concerned about this respondent number 4 who has closed my application based on a correspondence.
Did you understand Leonard GP's argument? He is saying renewal application submitted by you was not considered because of 11-9-23 proceedings whereunder your name was removed from the panel of contractors.
Yes, sir. So I want to challenge the action of this respondent number 4 irrigation officer. Because he cannot consider this action of a letter of communication he received from the Panchayat Raj engineer.
He is saying, he is taking a technical objection that you should have challenged that 11-9-23 proceeding.
It is not communicated to us.
Now it is communicated, you please see. I am giving you, I am communicating it to you.
Yes, Your Honor. I can see it from the letter of.
According to it, need not be challenged.
Yes, Your Honor.
According to you, it need not be challenged.
I should be surrounded with this for me to challenge it. They should communicate it to me. I do not have this order at all. They are not
What do you say?
communicated to me at all. They are directly communicated to the irrigation.
Panchayat Raj, now you are taking shelter under that proceeding, so you have to answer.
Order. If you stated the reason for the eviction, that matter is not basic and 11-9 pertain to even in the copy challenge that the order also matter. Unless until that removal order is gone, but his name can't be renewed, his license can't be renewed.
Formally, you challenge that proceeding. I'll direct a writ petition to be tagged on to that writ petition. Otherwise, technically, he is right. Today, right or wrong, there is an order.
Unless this order is communicated to me, so that I should not challenge this order.
That is a ground of challenge in the writ petition. Try to understand.
Otherwise, this matter can be closed only when basic this paragraph.
Let him find.
One expedition already available in order. 2 months. The last case we had back that it has been set aside in such removal. That if you consider your lordship.
You take advice of your see whether it is communicated or not. Assuming it is not communicated, that is a ground of challenge. Challenge it. Without challenging, you cannot say it is not communicated. Court, hearing that matter, may suspend those proceedings, saying that it is in violation of principles of national justice. Challenge that proceeding. Please give him additional perception.
But in the meantime, your lordship, I want to draw your attention to a document called acknowledgement given by them at page number 108, your lordship. Page number 108. Last para, your lordship, last but one para. Meanwhile, Mr. PKA Constructions has requested to issue the acknowledgement for participating in tenders for a period of 3 months beyond expiry of the earlier registration in the category of civil, based on the clarification issued by committee. On that, they have agreed and issued. So that they have issued on 27, because the meeting and all will take time. That's why if the application, renewal application is in order, they issue an acknowledgement based on which I will be able to participate in tenders for 3 more months. That they have given this letter is 107 your page number, your lordship, 27/7/2023. This has expired last week. So this I want page 107 and 108.
Now action is pending in the management department. Now action they are taking. So madam, they
Please give him set.
No, your lordship, you can.
Today, it is not possible. I will hear the case.
This has to be interim, has to be granted, your lordship. Otherwise, they will not be able to participate in the tender. Maybe for a week at least.
Interim relief has to be granted. Yes, interim relief has to be granted according to it.
This has to dismiss the letter because.
So he is saying it has to be dismissed.
No, but on what grounds, your lordship? They do not serve the.
I have to give them opportunity. Party cannot show anxiety. You cannot demonstrate your pain in the court. Why are you getting?
By law only, again, your lordship. What the 108 page number, your lordship.
When you argue your personal case, then that is, you are taking so much pain. I said engage a lawyer. You don't engage a lawyer.
Lordship, 108, only 1 minute, your lordship. Only 1 minute will come. He's talking about the letter of executive, this National Highway Department again. Just now I was talking about Panchayat Raj Department letter. Now he's taking the shelter of some rider which he has placed about this RNP department in 108 page number, your lordship. Only this I want to be extended until disposal of this appeal, your lordship. Let my appeal be dismissed in the very next hearing. Until the disposal of this petition, this interim order may be granted, your lordship.
Tomorrow?
Kindly, your lordship, if days are going, we are missing the
He
tender.
is insisting for interim order. I pass order here or there.
Yes, why not?
Pass order. I am telling you, you will have problem. Tomorrow, if I pass orders, then don't say. The court did not come to your rescue. Okay? Take advice of a lawyer. This technical objection is taken because Panchayat Raj Department has issued these proceedings removing you as a special class contractor. Based on that, they have rejected your renewal application.
They are a party here. They are not producing the evidence that they have submitted the copy, sent the copy to me. They are party in this petition.
10-11.
Tomorrow.
Not tomorrow, 10-11. Next. Other matters, please mention. Take up whatever possible. Take page wise.
Lordship, item number 86, 87 and 88, my lord, any date Lordship may take it up at 2:30.
Yes, I have noted. I'll note down.
In the caption of 2:30, my lord.
Yes, I said wait, 86, next man, next. 85, yes.
89, my lord. 89.
89.
Item 122.
In page 6 first.
Item 197. Item 97, your lordship. 97.
1 minute, 96. Yes.
97.
1 by 1. 104, 90.
91.
Why are you going back?
97, your lordship.
In 90, your lordship, you can find the same petition.
97, your lordship.
Tomorrow or some other day, you leave it to me. Just mention that. I noted.
Tomorrow, your lordship.
Item 109, your lordship. 109.
Calling page 7.
97, your lordship.
Item 97 to 1.
97, your lordship. 97, tomorrow, your lordship. 97.
Yes, tomorrow. 105, I have noted. Take up, what can I do? 5:30, it is late.
Malad, item 126.
120.
126, Malad. Not like 40. Motion is not.
Next page. Triple one, I have noted it will come up tomorrow.
190.
Yes. Warning mentioned matters will come tomorrow. Come. Yes, Jagat.
122 euros, tomorrow. The memo is
22, yes.
121.
Yes.
24 minutes.
126.
126 also.
Already the law, it's covered by the lordship's order, my lord.
There are two matters, one matter does the.
126 tomorrow. Mentioned matters, please don't mention again, they'll come up. 230 matters
97
will come tomorrow. I said it will come up tomorrow. Reflect 120.
Item 109 Your Lordships.
Second number 90, 115.
Okay, Kiran. Yes, this first.
97 tomorrow, Your Lordship.
97 to
Tomorrow, 97, Your Lordship. 97, Your Lordship.
2007 minute, after that given, 21 minute people are given this construction permission minute. Remaining people are interested.
please give the pass on order.
Same are minute, just item this plot number 186. The matter minute.
1 minute, 1 minute. Item 126.
126. Same, only plot number changes. Respect of 186 plot number. This case people got suspended 184 plot number. The instructions that matter are given, the direction supposed to third, second minute, another repetition. In that minute, at that time, instructions came minute. You will also pass order minute, same order.
Here also you have building permission.
Yes.
In similar circumstances, order will. Noted. 120 noted.
Item 109 Your Lordships. 109 Your Lordships. 109. Obliged Lordships.